Well, I'm mentioning 1885. But if it is not heard by tomorrow, the AP will be become infectious. But
Hand over the slip.
well,
May I have
by
Lordship's
tomorrow,
kind
by
leave to-
tomorrow, because not-
Please hand over the slip mentioning the urgency.
For release, because challenging the same impugned order, two civil divisional applications have been filed. One has been seized by court number 2. So I am praying for release of this so that both can be heard.
May I have my lord's leave? This is also for,
tomorrow.
this is also for release. This was heard by.
Interim order is expiring tomorrow.
Okay.
If tomorrow is declared a holiday, I'll come and disturb your lordship, my lord.
Declared a holiday.
If yet previous year it was a holiday. Roth was a holiday.
So there is a precedent.
So all programs have to be, my lord. It has to be, my lord, rewritten. If tomorrow the programs of tomorrow have to be shifted to the next day, and my lord, if it is holiday, I'll come and disturb you.
May I be permitted to mention one item, my lord, item number?
If tomorrow is there, my lord, kindly include this for extension of interim order tomorrow.
Calculate tomorrow extension.
My lord, item number 1368 of the monthly list, my lord. I have earlier mentioned this matter, my lord.
Upgradation.
Not only upgradation, my lord, I am facing one demolition proceeding. My lord, this is an application under Article 227 challenging the order and judgment passed by the KMC Building Tribunal. My lord, that particular order, my lord, this or the original order passed by the Special Officer Building, which was passed in 2006, my lord, that had two parts. One was the
When
demolition
the
part.
demolition will be affected.
My lord, 27th. Earlier there was demolition was
July.
July. My lord, by this time there were earlier notice on the basis of
My
that.
lord's leave, my lord, item number
Well,
107.
grateful, man.
Now, this
Upon
is
notice, I
going to
mentioned.
come for the first time, and there is no caveat. The urgency is that despite there is a plain case that I'm constructing over my property, my lord, the learned appellate trial court below, my lord, has injuncted me. The building plan is going to expire, my lord. Just, my lord, I will take only.
Order 39 rule 1 and 2 allowed.
Not allowed. They went for appellate court is allowed, and I am challenging that order with your lord.
My lord,
Kindly, my lord. And my lord, there is another for release, my lord, for release.
Ma-
This matter was mentioned with your lordship. It's the point which Section 12 of the Commercial Court Act will be heard prior to any other interlocutory application. My lord was pleased to accept the mentioned. Yes, it may, my lord, the matter is appearing 1039. Now, my lord knows the time frame for filing of the written statement. It's mandatory. Now, that will expire in the next.
There's an interim order. Mr. Rai. In the civil division, there's an interim order.
That has been challenged. I filed an application, turned down my application, rejected for hearing of the injunction
You have
application.
to advise your client accordingly. Hand over the slip, yes.
my lord, it's an very urgent.
This matter was fixed today, like by the earlier.
Please hand over the slip. Yes.
My lord, in this matter, urgency is there. Evidence already been closed by the city civil court. I have not get any impel for argument. Argument part hard.
Arguments completed.
Not complete, part hard.
What is the order under challenge?
Recalling the evidence.
Recalling of evidence.
This is the only evidence.
Arguments are hard. What is the next date fixed?
Next date fixed, no, not fixed, my lord. This is 21 5th, last day of vacation. That after not been given. Very urgency, my lord.
Hand over the slip. Yes.
With your lordship's kind permission, may I mention, lordship, CO number 2654 of 2020-25. As per the last order, your lordship, the matter was fixed for today at time fixed 2 p.m. by the learned predecessor bench. Somehow it has not appeared in today's cause list.
Hand over the slip. Yes.
Lordship, I am opposing.
Lordship, the only difficulty is the arbitration proceeding is lying stayed for last 1 year. So that's why the learned predecessor bench has given a fixed time for today.
Yes, I will consider that. Yes.
Order of me passed in recent. The matter was heard by Justice Rai, but no interim order. On the return the matter appeared, but on that day there was no resolution. For that reason, my matter was not taken.
Hand over the slip.
Lordship, in this matter only interim order is expiring. Lordship, I have given the notice of.
On the ground of extreme urgency for upgradation of the matter.
Hand over the slip.
Seeking leave to file without certified copy. Of the, I have the appellate tribunal's order certified.
What is the urgency?
Demolition is the 19th.
Appellate tribunal means building tribunal.
Well, the order of the lower court, well, I mean, the hearing officer is not there, there's no certified copy. Applied for the certified copy. And need to move this on, my lord, at least on Friday,
Yes.
19th.
Extension of interim order.
Please hand over the slip. Indicate when it is expiring.
For inclusion.
Under the heading,
The matter was running in June monthly list, but
under what heading?
it's
Please ascertain, then mention. Yes, call the list. Please show that. Xerox copy থাকলে. Please hand over the slip. Yes.
May I be permitted to mention one matter without certified copy?
Why, what is the urgency?
They should fix for hearing, but my application was Ward 7 Rule 11. That was rejected.
What is your application?
Application for rejection of plaint. Ward 7 Rule.
Rejection of plaint. Arguments done. No urgency. Please file with the certified copy. Yes.
Then one more thing, shall I serve a copy of this resolution application on the corporation?
Please serve. Yes. Item number 1. Who is appearing?
Lord, Mr.
My
Bhattacharya.
lord, I am for the opposite party, my lord.
Yarar.
CEO. Lord, I am for the opposite party.
Here, it কি দিয়েছে? কার্ড বেঞ্চ দিয়ে দিয়েছে। Yes.
Yes, Mr. Bhattacharya is appearing. Lord.
Was get infectious because when on 26th February they cross-examined, my lord. At least, my lord, 40,
Since I'm not inclined to
40
take up,
question, my lord.
since I'm not inclined to take
To your lordship, I'm for the petitioner. The parties have amicably settled the matter among
learned advocate appearing for the
Lord, I am for the petitioner. Lord, I am caught in a peculiar circumstances in this matter because on
that
the
date.
date and difficulty is that on that day I submitted that 31st July is the date fixed. That is why Lordship was pleased to direct to take it up on the matter. But the case status report on that day when I was arguing, it was there on 31st of July 2026. I have the document. And then
So I'm only recording that it is fixed on when?
28th of August. My lord, then I will only pray for one indulgence. I may be granted one liberty to pray for preponement of, my lord, the date. Because 28th of August takes us to almost before the puja vacation. So this
date of, so now we are at the end of the July. So it's difficult.
Why I am saying that?
Serving them, then a date will be fixed. It's difficult. I'm only
why I am saying that because it was filed on 20th of January. This
if you
application.
want, I can make that observation, but I think it will be difficult. It will go to that date.
Actually, kindly, my lord, grants the liberty.
Mr. Chatterjee. Yes.
I'm for the petitioner. Malad, if you will also kindly have a look at the first order passed by your lordship on 16 July 2025. Order of admission passed by your lordship. Amendment for incorporation of 2G. Just
In a suit under section 6,
under section 6. During
that has been rejected.
that has been rejected on the ground that
Mr. Haldar, that cannot be allowed. That cannot be allowed. There's a coordinate bench decision. Yesterday I have come across. I'm keeping it tomorrow. Please come ready. I will dispose of the matter.
Malad,
Yesterday I have come across that judgment.
coordinate judgment.
Cannot be amended. Suit filed under section 6. You cannot amend it by making it under 2G.
During passage of time, my lord.
Yes, yes. During the pendency. During the pendency of the suit was filed under section 6. Original defendant died.
My lord.
Thereafter, heirs have been brought on. 5 years elapsed. Then 2G. Cannot be done. That is exactly your case.
No, in the instant case, my lord, the original tenant died. Just after that, my lord, we filed after 1 year. And during pendency of the suit, my lord, 5 years elapsed. Now, my lord, I want to. My lord,
Cannot be done.
By operation of law.
Mr. Haldar, I am bound by that judgment. Please consider that judgment. Come tomorrow. I am keeping it tomorrow.
What judgment, my lord, can be?
Such work, Mr. Haldar. Find it out. I can only say it's the judgment of the year 2019. That much I can say. Passed by Justice Bhattacharya.
Bhattacharya. Sobuchari Bhattacharya.
I've forgotten the cost title. If I can collect, I will give it to my officers.
Can you extend the interim order? Can you fix a date?
Tomorrow I will dispose of the main matter. Tomorrow. The interim order is still when?
It will expire, my lord, because your lordship is not sitting in the next 2 weeks. Just for 2
When
weeks.
it will expire?
Expire till end of July.
Till end of July. Tomorrow I will take it. Kalke rekhe din, judgment. Yes. This come with that. No necessity to extend. That is so everything wrong. Yes, next.
My lord, I am for the petitioner, my lord. The wife in a matrimonial suit is the petitioner before your lordship. I have challenged an order under section 36 of the Special Marriage Act for alimony pending delight, my lord.
Yes.
My lord, I'll just state the brief facts, my lord. The matrimonial suit has been filed by the husband seeking for a decree of nullity, my lord. It was initially filed in the court of Thane, then by the order of the Honorable Apex Court, it was transferred to the court of Alipur. After appearance, the wife filed an application under section 36 praying for alimony pending delight. The wife also filed
25,000 has been directed. How much you want?
My lord, the income of the husband is at the point of time of 2021, it was almost 2 lakhs.
Please show me the documents with regard to that. Per month?
Per month, my lord. Per month.
Please show me that.
Kindly takes up the affidavit of assets filed by the husband, which is at page 102. It is in the first volume, my lord.
102.
No, my lord, that is the affidavit in. Kindly take, yes, 102. Kindly sees. Yes, Miller kindly takes a 105. Here the 105, the details of income of deponent, Miller. Kindly sees the monthly income, Miller. 1,90,000, Miller. He has also annexed the payslip wherein it shows. The payslip is at page 222, Miller, in the second volume. page 222. My lord, here this is the pay slip for the month of June 2021. Kindly sees the total earnings, which is 2,63,238. And the net salary is 1,91,000. That is a net salary, my lord, not the gross salary. And what has happened, my lord? The order was passed ex parte. After the husband appeared, filed their objection, and the affidavit of assets, he did not appear. Thereafter, it was taken up ex parte.
Show me that this document was considered, how it was.
It was not considered. That is my main grievance, my lord. The affidavit of assets of the husband has not been considered at all. The amount has been fixed only on the basis of conjecture, my lord. And what the husband is trying to do, he has filed a withdrawal application of the matrimonial suit. Now he is trying to withdraw the matrimonial suit, my lord. That is pending for orders. My lord, this is the plaintiff's application for expeditious disposal of a suit for declaration and injunction, my lord. My lord, the suit has been filed relating
What
to
is the stage of the suit?
the stage of the suit, my lord. This is the last order which I have of passed on 25th June. 6th August has been fixed for framing of issues, my lord.
6th of August.
6th of August, and the petitioner, my lord, is 71 year of age, my lord, and the suit has been filed relating to the retirement benefits of the deceased husband, my lord.
This application under Article 227.
Item 7, I appear for the petitioner, Lordship. The petitioner is a non-notified co-sharer who has filed a Section 8 West Bengal Land Reforms application in the learned trial court. What he is assailing
Who are
is,
you, preemptor?
I am the preemptor.
Preemptor or preemptee?
I am the preemptor.
Yes.
I am the petitioner. I am the non-notified co-sharer. I am assailing an order of rejection of Order 6, Rule 17. It has been rejected on the ground that I have made the application after the trial has commenced, and it will prejudice the opposite party. What I am trying to amend is that the impugned deed, in question, in the schedule of the impugned deed, there are 4 separate plots of land. 4 sets of plot of lands were transferred but by accidental omission, Lordship, I had included in my application only 1 plot of land. I am trying to by way of amendment include the other 3 plot of land, and whatever the consequences are for that, I have to bear, and I will do it.
What consequence?
Consequence means he will not be prejudiced, because if these are separate plot of lands. The separate plot of lands, if included, obviously I have to give I have to pay what the statute requires. I have to make that payment. But
How
for
can it be
this
done now? It has become barred by limitation, sir.
Lordship, it is the same impugned deed.
Maybe, but you have not deposited the consideration money.
I have deposited the money for that the
One plot.
The plot of land which.
Yes. So now, if you incorporate that, it is already barred by limitation. You cannot maintain a preemption for those plots.
Lordship, only one intelligence is that my right. I have exercised my right of preemption on time.
Barred by limitation. If you say initially exercise preemption right for 1 plot, you cannot include 3 plots.
Lordship, only one. Lordship will consider one thing: the question of
when the
limited
preemption application was filed
in 2022.
2022.
Sale
And now, and when you have filed the application,
2025.
So already 1 year. Even if you take 1 year period of limitation, that is also over.
Lordship, one thing is this question of limitation can be
part.
Can be
not a mixed question of law and
may,
fact.
May I?
A mixed question of law and fact, yes. You are right. Plaint can be allowed to be amended. Limitation will be an issue. But if it is ex posse part,
may I rely on a judgment, Lordship? May I rely on a judgment?
Yes, sir.
Lordship, 1969, 1 Supreme Court cases, 869. And another one, Lordship, of our High Court, The
This is at what stage?
this is-
Cross-examination of PW1. When did you file that application?
I filed the application once when the when the trial had commenced, a cross examination had started.
So 69 judgment did not have the occasion to consider the proviso to order 6 rule 17. So it might not
Lordship,
apply here.
Lordship, in that case, it was had been followed by a 2019 judgment. It had been followed. Lordship would consider para 4.
You have not brought the 2022 judgment.
2022 Lordship, I haven't.
You have not brought.
I have not brought.
This application, anything more? So you want to, which paragraph of this judgment you want to rely upon?
2019, Lordship, 2019 para 4 and para 4 only to show the stage where the amendment application was brought, and para 9, para 4 and para 9 of 2019. And there is another our High Court's judgment I have handed over, Lordship.
Our High Court judgment, where?
It's a 1992 judgment. It's para 6 I am relying upon.
1992, that is also pre-amendment.
Pre-amendment.
1992.
But it is on the point, Lordship, that a limitation cannot be a ground the for refusing the amendment application in a preemption case. I have handed over, Lordship. I have had. Oh, sorry. Yes.
Which paragraph?
Para 6.
Paragraph 6.
Paragraph 6, Lordship.
Ashwin. This application under Article 227 of the
The schedule is page 21, Lordship.
4751.
Schedule is page 21, Lordship.
7. No, this is 4557. Where is 4751? Which deed is 4751?
Lordship.
This deed is the deed you sought to preempt.
Yes, Lordship.
That was 4751. Which you have annexed.
4751, Lordship. This may be a mistake. 4751, Lordship. Yes,
Yes.
Lordship. This is only annex, Lordship. 4751.
Page 16.
Page 17. The deed starts, Lordship.
Page
17.
Yes, page
Four-
17.
four
Please see at
seven-
the top.
4751 of
4751
of 2021.
Yes,
Lordship.
please show me the schedule.
Schedule is in page 21, Lordship.
21. So 53 and this 8, 2 and 13.
Yes, Lordship.
This 3.
Yes, Lordship. So 53, I have filed the application. 53 is already there. I am through this amendment trying to incorporate the other three, Lordship.
But how much amount you have deposited along with the preemption application?
This Lordship, this I have paid for LR 1170. I have paid that money.
1 lakh. 1 lakh.
I have to
Yes,
take
paragraph
instruction.
8. Paragraph 8.
Paragraph. Yes, Lordship.
That is.
But this question has not arisen. This question has not come up. Nobody has questioned this till now, Lordship.
Sir, your preemption application is barred.
Lordship.
It's absolutely barred now.
Somebody has to raise this. This question has
Section
not.
3 of the Limitation Act. Nobody has to question. It's the court's duty. It's the court's duty. Please.
Lordship.
Nobody has to question.
Lordship, yes, but till now it has not been. At this stage, I am assailing the order 6, Rule 17, Lordship. Kindly consider this. I am assailing order 6.
Application. It's a frivolous application. Suit is frivolous. This application.
I will not waste any further, but I tried whatever I could.
Killer. 07 of 2022.
Lordship, the next two matters are also similarly placed, but I have a better footing in that sense the trial has not commenced. And it's a copy paste order which records the trial has commenced, but it has not commenced.
Trial has not commenced. The পরের গুলোতে তো না
But it's a copy paste order, and the court has said the trial has commenced.
ওইখানে একটা অর্ডার সেম হবে, শুধু একটা সাবমিশনটা একটু রেকর্ড করবেন।
But I have been practicing here since 2020.
Since 2020?
2020.
Yes. Just call the next matter.
Well, item number 10, my lord. I am appearing for the opposite party. If the court will direct, well, I will contest the civil revision application. But I am appearing for the opposite, but there is no caveat.
There is no caveat. You want a copy?
Yes.
Let me see. Yes, Mr. Chakraborty, what is there?
আজকে করবো তো?
Mr. Chakraborty, let me see what is there.
Yes.
Then if I find something.
My lord.
Otherwise.
Yes, yes, very,
yes.
According to me, very good case. My lord, this is, I am for the defendant petition. My lord, this impugn order is, my lord, relating to my rejection of my application under 7(1) on the ground of limitation.
On the ground of limitation?
Yes. My lord, the suit property is a go down.
When the summons was served?
My lord, no summon has been served at all. This is my positive case. My lord, this is a suit property is a go down. It has been admitted in the plain that go down remains under lock and key. The bailiff went and found that it is under lock and key. The postal report came that it is closed. Still, that report has been accepted as a good service. My lord, on the next date, it has been fixed for ex parte hearing. My lord, I appeared, my lord, on.
When you appeared?
I appeared on, my lord.
Your application under 7(1).
Yes, my lord. Kindly see, my lord, page. My lord, order number 7, my lord.
Order number 7.
Order number 7.
Then it's the entire order sheet.
Yes.
Yes, order number 7.
My lord, before that, my lord, kindly take note of the previous order, my lord. How it has been, how someone has been, my lord, accepted by the House.
All right, I will come to that. Please show me your application under 7(1).
Yes. My lord, that will be appear from page 36.
36.
Yes. That the defendant has not been served with any summon of this suit, either through court bailiff or through postal authority. That the defendant approached to the office of the plaintiff on 13/3/2026, requesting Vidyananda Sureka, being one of the trustees of Sureka Trust, having office at 61 Pathuria Ghata Street, and requested him to effect and or permit some urgent repair at his tenancy situated at the ground floor of premises number. The petitioner has not been served with any summon of this suit. The defendant being a tenant in respect of one room situated on the ground floor of premises number, that the said room needs urgent repair, as no repairing has been done regarding the said room for a considerable period, and as such the petitioner went to meet the office of the said trust, requesting for effecting repair of the tenanted room of the defendant on 13/3/2026. On such meeting and request being made for permitting the petitioner to effect some repair, the petitioner was scolded in harsh language, since the petitioner earlier gave a notice to the said trust expressing some of his grievances, and it was declared openly that within a short period the defendant shall be thrown out from the tenanted room situated at. That the aforesaid behavior appeared to be very much strange and dubious. The defendant petitioner immediately contacted with the learned advocate and expressed such incident to his learned advocate. On hearing the petitioner, the learned advocate of the petitioner suggested for making inquiry and or inspection from the court of law to ascertain as to whether any suit or proceeding for eviction has been filed against the present petitioner regarding the tenancy. Next part, situated at that. Next, that the petitioner instructed his learned advocate to do the needful. Accordingly, an application was made before the learned small causes court at Calcutta on 16/3/2026, and inquiry as to the whether suit for eviction is valid. Next, that your petitioner get information from this learned court on 20th March 2026. On that day, he get the information, and application was filed, my lord, within 5 days thereafter. My lord, now, my lord, your lordship, kindly see the order number 5. How the summon has been accepted, service of the summon has been accepted. Kindly,
Chakravarti, why did you not deposit the amount on 25th?
my lord,
Why did you not deposit the amount on 25th
lord,
of March? There is no requirement to file any application.
yes.
So you are obliged to deposit the
My
amount.
lord,
on
I have
25th.
stated, my lord, I have stated that, my lord, I have not been given the, my lord, receipt, my lord, regarding the payment of rent.
No. You will be depositing in the court.
No, I have stated.
The law says you have to deposit.
My lord,
Law does not say you have to make an
kindly see, my
application.
lord, I have filed on 25th.
No, why did you file an
My
application?
lord, within a, my lord, next, my lord, 25th, I have filed.
Within 5 days. I
Yes.
accept that.
Oh, no,
But Mr. Chakravarti, my question
No,
to
my
you
lord,
is,
my lord,
why you did not deposit the amount on that
my lord,
day?
I am praying for the order, my lord, because 25th I have filed, and my lord, order has been passed on 27th. Within 2 days. Within 2 days, order has been passed. My lord, now kindly see order 5, rule 17, my lord. What says, my lord? Order 5, rule 17, my lord. I'm drawing the attention of the honorable court, my lord. When the
Give a copy to him. Give a copy. Petitioner is directed to serve a copy.
My lord, my 21st July is the next date, my lord.
Friday, the matter will be taken up
Friday.
All right. All right.
I'm grateful. Sir, what we have
Yes.
Lakshmi ji and Lakshmi Prasad.
Yes, who is appearing? None appears for the petition.
My application praying for expeditious disposal of the testamentary suit. I am the petitioner, my lord. Initially, the application was
Revocation. No, the testamentary suit or the revocation proceedings.
revocation proceeding, my lord.
Revocation.
Revocation, my lord. Initially, it was filed in the year 2019, my lord. Thereafter, they appeared and it was registered as testamentary suit in the year 23, my lord. Thereafter, in the year 2024, I have filed an application for amendment of the application that is pending, my lord. Next date is 23rd of this month, my lord. I am
23rd of July.
sorry, my lord.
For
For hearing of my amendment application, my lord.
amendment application, that is 28th of February 2024.
2024. I have filed the application for incorporating some property in my initial earlier application, my lord. That is pending. That is fixed for hearing on 23rd July.
The learned advocate, this application
I've made this application for expeditious disposal by preponing the date fixed by the additional district judge, Your Lordship. No,
Expeditious disposal of what?
Of my misappeal. Your Lordship.
Appeal, injunction.
Injunction.
This application,
Your Lordship, the landed additional district judge has fixed September 2nd, 2026, Your Lordship, for hearing of the misappeal.
this application under article.
Now I'm for the petitioner, Malad.
Yes.
Malad, the petition, people lordship, Malad, the case of the case, the sister, a lady dependent number one, married in 2006, and her husband died in 2018. And in 2022, the sister filed a suit that there is no marriage. Marriage is not to record it, declare it null and void. After 16 years, Malad, since Malad some property, the defendant was sold to defendant number two. This application of defendant number two, at the time of evidence, Malad losses can see the marriage certificate I have annexed, that is in page 11. Marriage certificate of 2006 of defendant number one, and the husband died in 2018 after 12 years. Then I have annexed the deposition. Deposition where, my lord, some of my deposition, I purchased the land from the defendant number one. Some paper, because it is recorded her name, municipality mutated his name, her name, so I purchased. And thereafter, my lord, deposition.
No, certificate of marriage, it's not your certificate of marriage.
Maybe, but it is, my lord, what about the,
How did you get hold of this? This,
if I.
How could you get hold of these documents?
Other things, not only that.
Rightly it was marked as identification.
My lord, other things, my lord, this certificate issued by the municipality.
How did you get hold of this original?
My lord, I am submitting. This certificate I produce in no objection from the other side. So he can mark the.
It was on identification. You could not.
But I got from the
that.
If I applied for the.
You can you prove that it's identification. If you can prove those, it will be marked.
Then
as
losses can 3 items.
You are well acquainted.
Marriage certificate, not only that.
Identification. Your evidence is going on. Your evidence is going on. Please bring evidence. Please prove that it can be marked as exhibits.
I'm sorry. Thereafter losses can see. Not only the marriage certificate. Thereafter, legal aid certificate issued by the Bhaddeshwar municipality. Because I have purchased the land.
Issued in whose favor?
Issued in favor of the defendant number one.
So, show me how have you got hold of those?
I got it from the that is original.
Tell that in the evidence.
That is original.
Evidence.
The documents issued by the.
You have to show the basis for producing.
Listen, next, my lord.
Lead evidence with regard to that.
fact
Lead
of the
evidence with
identification
regard
name
to
of
that.
Shikha Datta Sen in
Mr.
Marcus.
Chakraborty, what you are saying, that's not in your evidence.
My lord,
What you are saying, that is not in your
my lord,
evidence.
if the
Your
documents
evidence is going on.
no objection given from the other side. My
No.
lord, Lordship can say then I filed application under section 125,
You
151.
please, prove
Lordship can
those.
see the what happened. One defendant number one is ill. Dependent number Lordship can see. I have purchased land. When
Foundation of those you have to say. You have not told that. You have not said in your evidence. How have you got that? How did it come to in your favor, in your hands? Those
that is-
foundational basis has to be said.
my lord, Lordship
You have
can see the
obtained-
order sheet. Order sheets they have said that the defendant number one is ill. Plaintiff said. So if I have to protect my
when you are producing some documents to be marked as an exhibit,
Well,
it's
there
your
is a
responsibility.
judgment, there is a judgment, Malad, that the it is have to my exhibit with objection.
If it is marked exhibit without objection, it cannot be called in question. It's the other way around.
There is no objection, Malad. There is no objection.
It's not that if you there is no objection, it has to be marked as an exhibit.
Well,
There's no law with regard to that. Unless you prove that it's
Well,
as identification.
Well, I can get the certificate from the magistrate after application. That is what certificate I will get. Everybody will get that, Malad. That is genuine one.
Mr. Chakraborty, please lead evidence. Your evidence is going on. It's
None evidence has closed, Malad.
No. It's going on for further evidence of DW1. You produce evidence to prove that it has not been rejected.
I'm submitting. Losses can see the order.
Mr. Chakraborty, it has not been rejected. It's on record, marks X for identification or anything as identification. You prove those things, it will be marked as an.
Losses can see the order sheet. Order sheet.
Yes.
That the defendant number one is ill. That opportunity they are taking. Should be the property, my lord. My property in question, I paid money, my lord, that is. After saying this, she's process and plaintiff filed a written objection to my application of 1/5 number, submitted the defendant number to file this petition by suppressing that the file and only the support of the defendant number one and prove the case on behalf of the defendant number as she is a psychiatric patient. As she is an advocate now become ill, not psychiatric, ill. So they're taking opportunity of a malad. What is my position? I have purchased the property, my lord. I purchased the property in 2020, my lord. After seeing all records, okay, in favor of the defendant number one. Mutated in her name, Arwara in her name. So in that circumstance, this is. So how I can save my property?
Bring the marriage register who has issued the certificate.
But that will be produced. That will be produced.
Produce him, then it will be marked as an exhibit. Bring him.
Well, he has agreed. I understand. He has agreed.
So lead those evidences. Ashwin.
The record that I can produce further evidence.
That's always there. It's only it has not been rejected.
Perhaps
it has not been rejected. It has not been rejected. It's marked X for identification, Y for identification. The order dated In exercise of jurisdiction under Article 227 of such as
I am
recorded.
appealing for the petitioners, my lord. This is a case, my lord, for early disposal of the application of the petitioners, my lord. Under order 39.
Early disposal of what?
And under order 39 rule 4 and also the pending suit, my lord.
Order 39 rule 4.
Yes, my lord. Order 5, my lord. Order number 5, it has been mentioned, my lord. The application was filed 19 June 2025, my lord. It is still pending.
You are the defendant.
Yes, my lord.
This application under Article.
My lord, I am the plaintiff in this instant case. My lord, this title suit of 1999 of 2024 was instituted by me, challenging the very document which contained the arbitration agreement. My lord, I will tell the facts very briefly. I entered into an agreement, purported agreement, which was supposed to be a deed of mortgage, but which was registered was subsequently a deed of development agreement. So I, being the plaintiff, challenged this in the lower court. And after that, my opposite parties filed an application under Section 8 of the Arbitration Act because the deed of development agreement contained an arbitration reference. So the trial judge, what he did, my lord, he disposed of the Section 8 application, allowing the parties to be referred to arbitration, and also on the same footing dismissed the suit. So our challenge is on with respect to that aspect, that Section 8 application, when we are challenging the very character of the document, not only its contents, the Section 8 application which was preferred by them, and simultaneously the suit being dismissed after allowing the Section 8 application, from that order we have come up before your lordship in the civil revision. My lord, order dated 23rd of February 2026. Order number 14, my lord.
Yes, please show me your plaint. Please show me your plaint. Please show me your plaint. Page 15, your plaint starts.
Yes, my lord.
Please take me to those paragraphs where it has been stated that according to you, it was a deed of mortgage.
My lord, please come to page
Please
number.
show me your averments with regard to your case of mortgage being made out in the plaint.
My lord,
Which
please-
paragraph?
My lord, paragraph 7, page number 16. Thereafter, in due course of treatment, a huge amount was required again, and having no other alternative. This paragraph.
Yes, so according to you, in the garb of a mortgage deed, a development agreement was being executed. So you are challenging that. What is your prayer in the plaint?
My lord, come to page number 21, Lordship. Lord, for a decree of declaration that the plaintiff is the joint owner of the suit properties, having 8 owners equal share, along with pro-defendant number 2. Lord, prayer number 2.
Basically, you are alleging fraud.
Yes.
So the arbitrator can also decide the issue of fraud.
No, my lord. My lord, my point is that Section 8 application does not determine the suit to be dismissed. We have
So if the Section 8 is allowed, what remains in the suit to be decided? What remains in the suit to be decided?
Lord, I have judgment.
So the suit, the dispute in the suit, that is being referred to the arbitration. What will remain in the suit?
No, Lord, our contention is that the fraudulent misrepresentation as to the character. We are challenging the very character of the document itself.
Do you have any decision in your support with regard to this?
The relevant.
These are the relevant excerpts from Lord the SCC, the relevant paragraphs. The interpoint.
Suzalem, those exceptions.
Jerusalem, and that was not extended by a subsequent judgment of the Supreme Court to say, Lord, what class of fraud can be, Lord, agitated before the civil court? What class can go before the arbitrator? Your Lordship
So
is
if
very
it is
correct.
relates to execution of the document.
Yes. And now when, Lord, the character of the document and, Lord, its existence is subject matter of a challenge, whether, Lord, that is arbitrable or not, that is one of the questions. Secondly, the pro forma respondent is, Lord, the co-owner. Therefore, Lord, that she cannot be relegated, Lord, along with, Lord, the plaintiff to an arbitration. That is the first judgment that I cited. A non-signatory to an agreement, whether can be relegated to
Sukonna Holdings.
Sukonna is not that was bifurcation. The Lordship is right. Bifurcation. That is a parent judgment. And following
Thereafter,
that,
Section 8 was amended.
Thereafter, it was amended in 2016. And Lord, now, Lord, the first judgment that I have cited.
Now, Mr. Mukherjee, the scope is wider. So the analogy what was there, unless you are a party to those documents, you cannot be relegated. A non-party cannot be relegated to arbitration. Now, any person claiming or under, they also come within the scope of, even
Yes, your
if
Lordship
he or
is
she
right.
is not a signatory to the agreement.
Yes, Lord, that is not what the Supreme Court has propounded on the basis of group of company doctrine. But that was not in the level of the individual
Group of
person.
company doctrine that was being considered in Sukonna, but Section 8, I think it's clear now. It does not speak of only the group of
Section
companies.
8, Lord, it says about the court has to be prima facie satisfied about, Lord, whether it is arbitrable dispute or not.
Because now, Mr. Mukherjee, the line of decisions is that unless it's expressly non-arbitrable, please send it to the arbitrator, let him decide expressly not non-arbitrable. So even if there is a dispute, relegate it to the arbitrator, let him decide on the question of
I have
jurisdiction.
tried to come out for blood with the exception to the proposition that your Lordship is saying. Blood, that is general proposition, blood. But I can come out having regard to the particular facts of this case. But first is that your Lordship has seen, blood,
Have
the
you
nature
seen
of
the plaint, Mr. Mukherjee?
I've seen. I've seen, blood. The
Is it
paragraph
happily
says,
drafted, Mr. Mukherjee, to make out a case of this nature of fraud?
but so far as blood, the misrepresentation as to blood, the execution and character of the document, they say that it was a case of blood.
Please show me the averments of your plaint.
But that is at page
15 it starts from.
It starts from 15, but not the relevant,
Relevant
paragraph.
paragraph.
But paragraph, your lordship may kindly see from my lord, paragraph 7 onward. Or my lord, your lordship may see from paragraph
And you
6
are also
onwards
not an illiterate. You are not an illiterate. So registration office, you went with those copies. So please see the allegations, the case which you are trying to make out, whether it's merely saying some advance agreed to lend against mortgage, then registration.
Yes.
Please look at the plain.
Yes, my lord, paragraph my lord, 6 onwards, my lord, reflect my lord, how the transaction went through.
Yes.
Then, my lord, it is true, my lord, that I was present before, my lord, the registering authority. But, my lord, I was there, my lord, only to understand, my lord, the character of the document which was executed. My lord, that was later transferred to be, my lord, a development agreement. But I went there for a.
Are you not a literate person, Mr. Mukherjee?
But but there is no averment to such effect.
Paragraph 11, last sentence. Sort
Are
to
not
make
able
out
to
some
read and
case.
understand. Not able to read and understand the content of the
You
same
can
case,
only
but
write
somehow sign his name.
Sign in English.
This is there.
What is the business you are carrying?
What is it?
What is the nature of business which you are carrying?
Roll shop. That I have stated, my lord, in the reply letter. That's the paragraph 17.
There is no caveat. There is no caveat. What is the finding of the learned trial?
So the learned judge was of the opinion, since there is a clause for arbitration at 8.3.
No, with regard to this fraud aspect.
8.13.
With regard to this fraud aspect, what is the finding?
So there's no finding. There's no finding.
What is your name?
Sharna Khodai.
Maiden appearance?
In this court, yes.
In this court.
Yes, my lord, in this matter, I am for the petitioner. This application for early disposal of the order 6/17, which filed by your petitioner. This application filed on 18 January 2025 till over 1 year. The learned trial court did not put in to dispose the application.
What is the next date fixed for hearing of that application? What is the date fixed for hearing of that application?
Next date is fixed. Oh, give me a moment, sir.
Application under Article 220 India is at the instance of the wife.
The next date is 29th August 2026. My lord, the next date is 29th August 2026.
My lord, I beg to appear for the petition. My lord,
Yes.
the revisional application stems from the rejection order of Section 24 Hindu Marriage Act application.
Rejected.
Rejected, my lord.
Why?
My lord, kindly comes to the impugned order, my lord, the operative part.
Yes.
My lord, may I read? Upon hearing both the sides, it becomes apparent that undisputedly the parties are a married couple. They are residing separately. Present matrimonial suit is pending between them. Their child, namely so and so, is under the care and custody of the petitioner/wife, who is the petitioner before your lordship. It appears from the plaint of match suit that the child was born in December 2007, who has already attained majority, and admittedly the wife has substantial income of her own. My lord, this is the primary ground for rejection.
If you have substantial income,
My lord, I'll come to it. I'll come to it, my lord.
you have income.
I have income, my lord. However, my child is right now he's pursuing his education from an.
That is your application for alimony.
My lord. Yeah. Application, my lord, for alimony, is on page 26, my lord. No, that's what we do. I apologize, my lord. It's in 39. My application for maintenance pendent life.
Yes. Show me the amount claimed.
My lord.
On what ground?
The amount was claimed, my lord. My lord, kindly comes to the prayer on page number 44.
Yes.
My lord, grant of interim maintenance rupees 32,300. 390 rupees per month. The child has been in my custody, my lord, since 2014. Initially, there was a domestic violence case and several cases happened, my lord.
No, have you given the details of the expenses?
My lord, I have attached my affidavit of assets.
Show me that.
My lord, my affidavit of assets is in page number 88, my lord.
Page number?
88. And the expenditure for maintenance of dependent children, my lord, my lord shall find it on page number 90 under point number 4. I have given the tuition expenses, hostel fees. Back then, my child was in a school. Right now, he's pursuing his education from an university which is in abroad, my lord. I have the fee structures with me. That cost of that university, my lord, itself is around 2,89,000.
Who is bearing that?
I am bearing that, my lord. I am bearing that all my own. Since 2014, the child is in my custody. Merely because, my lord, I have substantial income, I don't deny it. But because of the entirety of the expenses being on my shoulder, I have had to take out several loans. Now I am in debt. I have even attached my credit report, my lord. My CIBIL report, subject to correction.
By the order impugned, the application. Yes.
Your Lordship, I'm for the petitioner. I'm praying for the expeditious disposal of my revocation application, proceeding under Section 263 of Indian Succession Act 1925. PW1 is completed, and there was some issue in the chronological order of the exhibits. So the next date is fixed on 30th July.
For evidence of the dependent witness.
Yes.
This application under Article 220. Call the next matter. None appears for the petition at the time of
My lord, this is I have already served copy upon the opposite parties.
For the opposite
I am
party.
filing the affidavit of service. My lord, this is a civil revisional application which is arising out of two orders. Order number 215 and order number 216 passed by the learned 6th Fast Track Court, Alipur. My lord, before going into the order, I crave leave to show the background of the case, my lord.
What is the order impugned?
The order impugned is with regard to three separate petitions we had filed, one put up, one shifting back, and one petition recalling order number 215. So basically, my lord, in way back in 2023, yes, the learned fast track court was pleased to pass an order on 31/1/2025 for allowing alimony pendentile. The alimony was enhanced subsequently, and they had issued an order whereby the pro forma respondent, being the employer of the petitioner, to in 3 equal monthly installment to pay, to deduct the alimony pendentile from the salary. Now, my lord, thereafter the on in 18/6/26 order number 215, which is my first impugned order.
18/6/2026, yes.
Yes, my lord, annexure F. So this was the first order wherein before that I have annexed the petition. The employer of the petitioner came before the learned trial court in a petition stating that the arrears has now exceeded the salary of the petitioner, and they prayed for an enhancement of the number of installment to 7. As per a order dated 18/6/2026, the learned fast track court was pleased to enhance that installment of alimony. Now thereafter we had filed one shifting back petition and one petition for recalling order number 215 of 18/6/2026. That those petitions were rejected by order number 216 dated 25/6/26 without any reason. My lord, may allow me to refer to annexure 6, page number 85. I am reading the order, the second impugned order. Another petition for the third paragraph, another petition for recalling order number 215 dated 18/26, copy served. It appears from the last order rejecting husband's petition. The petition was allowed in the interest of justice for speedy trial. Considering the essence of the order, petition order 215 is or the petition for recalling 215 is instantly rejected for the reason, in spite of the earlier orders, did not comply with the court's order and avoided moral obligation, which is wrong, my lord, because already my salary is being deducted. The entire maximum part of the salary of the petitioner husband is.
How much is the amount due now?
My lord, the amount due as of petition dated
Near about 3 lakhs. Near about 3 lakhs.
Near about 3 lakhs. Yes.
There's an order for 3 installment. There was an order to be deducted within three installment each month.
My lord, may I refer to a notice dated 13 July 26 given by the employer of the petitioner. The arrear is given.
How soon can you pay off that arrears? How soon can you liquidate the arrears?
My lord, currently he has a salary, most of which is being deducted, and after the recent revision, only he has 6,000 to 8,000 which is coming to his account, and he has no alternative.
Why? What are
source.
the deductions?
My lord, as per this recent notification, 13 July 26, 28 per month from July 26 to December 26, and balance amount of 27,386 from the salary of January 27.
So this is as per the order.
Yes, my lord.
This is as per the order. I'm asking you, this can be lifted. How soon we will pay off this amount? My lord, at least 6 months will be required because the limited salary of the petitioner.
Salary slip is enclosed.
You have taken that risk, sir, by not paying. You have taken that risk by not paying.
At this point, my lord, the salary is being automatically deducted.
Has to
And he
be.
has no amount to
That is
suffice
what
himself.
that is why I'm giving you liberty. Please tell me how soon you will pay off. This will be lifted. This order will be set aside. But please pay.
My lord, kindly grants me time. I'll come back with instructions from the petitioner because I have to assess how much he can pay.
Not how much, the entire amount has to be paid. Entire amount has
My
to
lord
be
grants
paid.
me a week's time. I'll come back with instructions.
How many bank accounts you are maintaining?
Bank account only one, which is the salary account. It is in his
Except salary
affidavit.
account, you do not have any other account.
It is in his affidavit of assets, my lord.
No, affidavit of assets, I'm asking you. Except salary account, you do not have any other
Only
account.
one, my lord. He doesn't have any other.
What are you doing?
He was.
If you say that, then it's better let it be deducted in this way. Let it be deducted in this way. I'm giving you an option. If you can pay off, yes, this will be lifted. This order will be lifted, but you have to pay.
My lord grants me 1 week's time. I'll come back with instruction.
Tomorrow, not 1 week's time.
As my lord.
After some argument, the learned advocate appealing for the
Item number 22, my lord, I appear for the petitioner. My lord, may I, my lord, at the outset, beseech my lord to take this matter up along with my lord CO 430 of 2026, which is pending before this court.
What is this matter?
My lord, this is, my lord, from the order allowing, my lord, an application under section 10, thereby, my lord, staying the proceeding. This is, my lord, rejection of section 10, thereby, my lord, challenging that.
Rejection of section 10.
Rejection of section 10. My lord,
What
there
is
is
the
a
other matter?
other matter, my lord, there were two section 10 applications, cross applications, one rejected, one allowed. My suit has been stayed, the other is.
What are the two suits for?
One is for, my lord, the present, my lord, is for only injunction. My suit was for declaration and injunction. Declaration has been stayed. My lord, cause, my lord, the two suits are materially different. My lord, the court failed to appreciate that. If my lord takes the two matters together, my lord, it would, I would find myself in a
What is
better
the number of your suit? 486 of 2023.
Yes. 486. That order is not before my lord, but that is there at page 35 of the petition.
What is the other suit is 210.
210 filed by the opposite parties, only praying for injunction. My suit is for declaration and injunction, my lord. I am the, my lord, owners of the property. They claim via, my lord, record of rights. And I would also be praying that the suits be analogously tried, my lord. The issues involved are
The learned advocate appealing for the
This is an application for expeditious disposal, my lord, of a title execution case, which is pending before the learned fifth civil judge.
You are the degree holder.
Yes, my lord.
What is the miscellaneous case for?
My lord, what had happened is that I had succeeded in the appeal because initially my suit was dismissed. I filed an appeal, my lord, before the learned.
What is the mis case for?
Well, section 47.
It is pending.
It is pending, my lord.
So 47 has to be disposed of.
Yes,
first.
my lord.
Any other miscellaneous?
No, my lord. Only that one application is pending, my lord.
This application under Article 227 of the Constitution of India is at the instance
application, my lord. My lord, expeditious hearing, my lord, direction for. My lord, suit for declaration and permanent injunction, and along with my lord, Ismail right.
this application under Article 227 of the Constitution of India.
Learned civil
is
judge,
at
my
the
lord.
Maybe the lordship and for the petitioner lordship.
Yes.
This is a petition for expeditious disposal lordship.
Yes, of what?
For what? For a suit for decree of declaration of permanent injunction lordship. The suit is pending since 2022.
Injunction application disposed of or pending?
Your lordship pending.
It's ready for hearing.
Yes, lordship.
This application under Article 2
My lord, I am for the petitioner, my lord. My lord, amendment petition was dismissed, rejected with cost 500, my lord. My lord, kindly come the
Amendment of what?
amendment, my lord, the
Plaint.
Yes, my land over the plaint.
At what stage?
My lord, before trial, my lord. Before commencement of trial, my lord.
Where is the amendment application?
My lord, amendment application, my lord. Kindly pay. It's a detailed statement. My lord, case 86, one answer D, my lord. 54. Annexure D, my lord. Thereafter, my lord.
Page?
Page 86. Bengali writing, my lord.
Where is the schedule of amendment?
My lord, 88, my lord. My lord. সংশোধিত মানে আমার 87 মাইল তফসিল সংশোধন মাইল আরজির সপ্তম দশার পর অষ্টম দফায় পূর্বে নিম্নলিখিত অংশটুকু 7 পদ দফারূপে সন্নিবেষ্ট হইবে 7 ক বাদিনী বিমলা সাঁতরা তার জীবদ্দশায় তার পুত্র শঙ্কর সাঁতরায়
Where is the plaint?
My lord, plaint, my lord. Kindly come to my lord, page 12, my lord. সংশোধিত আরজি, my lord, annexure 12. Yes, my lord. Annexure A, my lord. This is the amendment petition, amendment plaint, my lord. Original plaintiff died, thereafter my lord son has substituted present petition. My lord, pair of the plaint, start page 20.
So what is the fact which you want to incorporate?
My lord, during lifetime of the plaintiff, original plaintiff, she made a gift in favor of the present plaintiff, that to be incorporated. By made a gift, my lord. He is the son of the original plaintiff, my lord.
Bimala Bala was the original plaintiff.
My lord. She died, my lord, thereafter, my lord, order number 67 dated 7/11/29, present petitioner was substituted. My lord, Bimala Bala, my lord, during her lifetime, she made a gift in favor of the plaintiff, present petitioner, that did to be incorporated in the plan.
When Bimala Bala passed away?
My lord, Bimala Bala passed away, my lord. My lord, 3/9/2018, my lord.
2018.
My lord.
And when this application for amendment has been filed?
My amendment has been filed, my lord. 31st January 2023. This petitioner was substituted in the year 2019, my lord.
Uh, the petitioner, the learned advocate for the petitioner may be justified.
But 27 is my petition. That is for expeditious disposal of the title suit that is pending since 2021. My lord. Suit for my lord, declaration and damages, my lord.
What is the stage of the suit?
My lord, PW1 is going on. Evidence of the PW1 is going on. My lord, next date fixed on 27th August 2026.
This application under Article 2. After that, if a time is fixed, no matters in the ordinary course will be taken up. Yes, next.
I am for the petitioner, my lord. I am praying for a expeditious direction for disposal of a title suit, my lord, which is pending since 2011, my lord. In the meantime, my lord, DW is going on for the tenants, and they have filed one application all on a sudden on 8 May 2026 for, under Order 8, Rule 9 for supplementary pleadings, my lord.
Order 8, Rule 9.
Yes, my lord.
That is pending.
That is pending since 8 May. Otherwise, the my lord,
When it is fixed for hearing?
27th July.
Written objection filed.
Yes, my lord.
They have filed an application for leave to file a subsequent pleading.
Yes, my lord.
This application under Article 220. that is allowed, then you might have to recall your own witness. That is why I have indicated, depending on that fate, it will be proceeding.
Yes.
Yes, next. Yes.
And my lord, I appear on behalf of the petitioner. There is a caveat, my lord. I have served, my lord.
My lord, I appear for the opposite party. I have been served just a while ago. So, my lord, I'm only praying for a week's time. My lord, keeps it
just now.
any day next week.
It was my mistake, my lord. My lord.
Your mistake or your clerk's mistake? Whose mistake?
My lord.
Your mistake or your clerk's mistake? Please speak out. Whose mistake?
My mistake.
Yes, what is this application?
My lord, I am the husband in the matrimonial suit, my lord. Suit
Then
on
you
the
have to
ground.
pay.
No, my lord, I will pay. I will pay. My lord, my learned friend's client has filed an application under section 24, my lord. Application is at page 26. Kindly, my lord, comes to page 29.
How much has been directed to be paid?
17,000.
What are you doing?
My lord, both are government school teachers.
Both are?
Government school teacher. Same pay scale. Kindly, my lord, comes to page 29, my lord.
Page 29.
Yes. Kindly, my lord, sees the prayer, my lord. It is therefore humbly prayed that your honor would graciously be pleased to direct the opposite party husband to pay a sum of rupees 30,000 only towards maintenance of our minor son every month from the date of filing of the instant application, and a sum of rupees 25,000 towards litigation cost and other order as your honor may deem fit and proper. Now, my lord, kindly, my lord, comes to page 56, my lord, the affidavit of assets and liabilities of the wife, my lord. Page 56.
Yes. What
Page
is the age
50
of the child?
9 years.
9 years.
Class 2.
What is your income? Salary?
Salary, my lord. Page 37, my lord, I have stated.
Please tell me what is the amount?
81,000.
81,000.
81,000.
9 years child, how much
Class
it is
2.
necessary for maintenance?
My lord, they had given
Is
the breakup.
studying in which class?
Class 2. No.
9 year class 2?
Yes. They are stated, my lord. They are
You
stated.
are also the father.
Lord, I have no access to my child only. I have been given no access.
Attempt to take access to the child. When have you last attempted to take access to the child?
Lord, I went, my lord, thereafter.
There are no custody petitions.
Yes, 9-year-old child. After all, you are paying for the son.
Yes, my lord, but they need to pay they need to give a reasonable expenditure. Kindly, my lord, sees page 56, my lord.
What according to you is the reasonable expenditure for a child of?
Kindly, my lord.
I am asking you. Not don't go by the records. I am asking you.
No, my
From
lord,
your
they
experience,
had prayed for 30,000.
From your experience, what is the amount which is necessary?
My lord, I'm telling you, lord, they had prayed, my lord, 30,000 per month. They could only substantiate 11,300. They could only substantiate the expenditure.
Where is that?
Page 56.
Yes.
Page 56, part 3. Kindly, my lord, sees relevant information relating to the children. Now, my lord, sees details of the expenditure on child. School and college fees, my lord, rupees 300 per month. Books, stationery, 1,000 per annum. Private tuitions, 5,000 per month. Outings, summer camps and vacations, 10,000 per annum. And thereafter, my lord, entertainment 500, others, my lord,
That is not required
3,000.
in summer camps and other things.
10,000 per annum. Summer camps, outing for class 2.
Yearly. How much?
Summer
You also go out?
Lord,
yes. So how much is the expenses?
My lord, only kindly, my lord, sees
how many
thereafter.
times you go out?
My lord.
Yes, how many times in a year?
My lord, kindly, my lord, sees the total expenditure given.
You must be having an idea. So what would be the expenditure in a year? 10,000 is exorbitant, Mr. Mondol.
No, my lord.
Because you have some idea about this. Outings and other things.
Yes, my lord. Kindly, my lord, sees the total expenditure. They could substantiate only 11,300. Now, my lord, kindly sees the order. Impugned order, my lord.
After all, you are paying for your son.
No, my lord, court has to come to a reasonable finding, my lord. What the court has, kindly, my lord, sees. May I place, my lord?
Admittedly, the petitioner, who is the respondent in the original proceeding,
Yes, where is your affidavit of assets and liabilities?
page 36.
Page 36.
Yes, ma'am.
What is your subject of teaching?
MSc B.Ed, my lord.
So that's your
Last year.
qualification.
Yes, my lord.
What's the subject which you are teaching in the school?
That, my lord, I need to take instruction, my lord.
You have to take instructions. Must be science.
Yes, my lord, must be
In
science.
which
my lord.
class? 9, 10, 11, 12. Private tuition income you have disclosed in your assets and liabilities.
My lord, he's a government teacher, my lord. How?
Oh, you don't want? You don't give private tuition?
Government teacher, how? Government teacher, my lord, how can?
They do not do. Recently, a circular has come. What was the necessity of issuing that circular, Mr. Mondal? Very recently, a circular has come for government teachers. What was the necessity for issuing that circular? Yes. You have suppressed your income, Mr. Mondal.
No, no, no. I have
Yes. Your income from other sources is 300 per month. Page 41.
This is what is given.
That will be the interest in your salary account only. And from salary account, to which account you are transferring those amounts? Have you disclosed your bank accounts? You have not disclosed.
No, my lord, kindly, my lord, gives me some time. Yes, my lord, page 44, my lord, I have stated.
44.
Yes.
How many bank accounts?
2, my lord,
Yes.
I have stated.
Only 3,000 balance.
Current balance, my lord.
Yes. Yes, what do you say?
Lord, I need to take instructions from my client. Kindly keeps it any day next week.
Any day next week?
Yes,
Or
ma'am.
this week?
But next week, my lord. Any day next week.
The learned advocate appearing for the opposite.
Great. Item number 30, my lord, in this matter, very short question of law involvement. My lord, the opposite party, my lord, being the, my lord, petitioner, appellant, preferred a, my lord, BT appeal against the order passed by the
Preferred a
BT appeal, my lord, before the municipal tribunal.
Building tribunal.
Building tribunal.
Oh.
My lord, that,
Before municipal, Bidhannagar Municipal Corporation. Yes, then what
That
happened?
order was passed on, my lord, 22nd of April 2024. And there are delay about 820 days. And
Rejected, section 5.
No, section 5 pending, section 5 pending, and stay application pending, a PUTA petition was filed suddenly on 30th June. And the court, without granting any opportunity, court stayed the matter without disposing of the Section 5 application. Order 43 of Order 41, Rule 30A, there is bar.
Ends of justice.
No, my
If
lord,
it is demolished, what will be done?
my lord, your lordship,
What will be done in the
my lord,
appeal?
my lord, your lordship, kindly, they are building.
There are division bench judgments saying that even during pendency of Section 5.
My lord, I am not putting this question, my lord. In terms of the High Court's order. In terms of the Honorable High Court's order, my lord, your lordship kindly consider the High Court's order. Case 75. Case 75, your lordship kindly consider. Paragraph 2. Accordingly, the corporation steps have been taken. Notice has been issued revoking the building plan permit, but they are not challenging the.
More so, stay has to be granted.
No, they are.
Otherwise, it will be demolished.
They have not challenged.
High Court's order directing demolition, it will be demolished. Mr.
No, they have not challenged the building plan cancelled. They have not challenged this order. They have not challenged. The order has been passed by the municipal corporation cancelling the building plan. That they have suppressed.
Against that appeal is there.
No, they have not challenged it.
What they have challenged?
They have challenged earlier order after 2 years, more than 2 years. Our
Dr. Learned Advocate
observation that without disposal of stay application, my lord. Your lordship,
The application has said, depending on the fate, if the section 5 is dismissed, then the appeal goes.
only one line, my lord, you lordship kindly add that without, my lord, they have gone through the merits of the matter. Your
It
lordship,
is however made clear that
that observation, my lord. Court will not go into the merits of the matter.
Yes, next.
Before your lordship takes up the next matter, my lord, item number 29, your lordship was pleased to fix the matter on 1st of August. Can it
Yes,
be?
yes, you agreed to that also.
No, my lord, my lord, my learned friend is also here. My lord, can it be on
my lord,
4th,
personal
5th, my lord,
difficulty, my lord,
anytime, my lord, on 4th, 5th, my lord,
kindly.
kindly, my lord.
1st of August, 1st of August. Yes, yes, yes. Next.
My lord, I am for the petitioners. My lord, the petitioners are the plaintiff in a suit for partition. We preferred an application for injunction that was granted, and it is extended till date. Now, defendant
For partition,
suit for partition.
yes, then
We, along with that, we filed an application for injunction, order 39 rule 12. That has been granted, and the order has been extended till date. Now, by this time, after getting notice, the defendant number
151 permitted to complete the construction.
permitted construction on the ground that the defendant has been allotted one room sanctioned for the Pradhan Mantri Awas Yojana. And the main allegation in the partition suit was that defendant is trying to construct in the front portion, depriving me. So, my lord, in that
Without claiming any equity.
my lord, in the partition suit, my primary allegation was that he is trying to make construction in the front portion. And in the front portion, if construction is done, then my lord, subsequently, everything will be frustrated.
You have a house in that undivided.
Yes, we all have different portions.
Yes, since
But-
you
but-
have, you don't want him to construct.
No, my lord.
Not-
My lord,
Let him construct. I will
my
make
lord, in
it
the
that,
front portion, my lord, that,
without.
my lord,
You have not constructed in the front portion. Front portion is left. Front portion is left.
Front portion is left, my lord, that is
You have
encroaching into
chosen,
my.
sir, you have chosen not to make any construction in the front portion. So according to you, the other portion might be the valuable portion.
My lord,
So the front portion is left. You could have constructed prior to him. You have not done that.
No, I could not have constructed, my lord, but that main allegation is that portion belongs to me,
You have
and that is the main
constructed.
allegation, my
Why
lord.
you are preventing your co-sharers from constructing that?
My lord, if construct, then subsequently everything will be frustrated by meets of bounds,
So
and
give your property.
he already have,
Construct in the front
my
portion.
lord, he
give your
already
property.
have much more share than he is entitled. So that
That,
is why, considering that the injunction was granted, my lord. Now, during injunction, this has been done. My lord, this will be a great difficulty after that.
If it is modification of that order, you say appeal lies. If it is modification according to you,
section 151 order, my lord.
Maybe.
Section
If it is in
151.
effect modification,
My lord, kindly
variation,
just one sees, my lord, the order, impugn order, my lord, the reasoning part of the impugn order, my lord.
it has been made, shall be subject to the final result, shall not prejudice to the rights and contentions. This application.
May I withdraw this application with liberty to file afresh? May I withdraw this application? Why? Inadvertently, your lordship, plaintiff, inadvertently, your lordship, the plaintiff has been stated as defendant and defendant has been stated as
For
plaintiff.
that, I am giving you
Your
leave to
lordship,
correct.
certain documents.
Yes, what is this matter? What is this? What is the order?
There are certain documents which I need to annex, your lordship.
What documents?
Well, the order has been, there is an order which has been passed under section, an application under section 144 of CRPC, your lordship, where the order.
You have the copy of the order?
No,
I can take it up.
on instruction, I'm saying, I do not have that copy, your
What is
lordship.
the order under challenge? Please kindly come to the order under challenge. 23rd of April 2026.
My lord. The second part of the order, your lordship. The application under order 30 under order 39 rule 83 has been allowed, your lordship. Challenging that order.
23rd of April.
That they have suppressed that there is already an order passed by the learned executive magistrate, your lordship, restraining them not to disturb my possession. That has been suppressed. I need to annex that order.
Yes, inspection has been directed. What is the difficulty?
They have suppressed that order, your lordship, passed by the
What order?
executive magistrate, your lordship.
That's it's not binding upon the civil court. Executive magistrate to maintain peace.
They have suppressed that order, your lordship.
All right, please give me the order.
Well, I do not have on instruction, your lordship. I am submitting.
You have saying that that order has been suppressed. You can give me the order.
On instruction, I am saying, I have pleaded, your lordship. I pleaded in.
Show me your pleading.
Well,
Executive magistrate can only pass an order to maintain peace and tranquility.
Not to disturb my possession, your
Can
lordship.
it be done? Please show me under 144. Where is the power of the executive magistrate to direct to restrain?
Order has been passed.
That's a nullity.
But they
Sir,
need to
if that
challenge
is
that
passed,
order.
that's a nullity.
But I do not have that order, your lordship.
Maybe
they need to challenge that order. Well, if it is
challenge that order in any forum, that's without jurisdiction.
But,
the civil court is not bound by that order. That's
page-
neither here nor there.
I have pleaded in page 4 that
Yes.
I have made a GD, your lordship. That is at the last three
Yes.
lines of para 4 and para 5.
Writ petition also is there.
My lord.
Writ petition for what? Police in action.
My lord.
Police in
disturbing
action.
my peaceful possession, your lord.
Police will decide the possession.
No, your lordship. Not on that point, your lordship.
Then what point?
But they are disturbing my possession. I am in possession right now.
So this is the injunction. Now the order has been passed. You are challenging that
I am on
order.
the point, your lordship. They have suppressed certain facts, your lordship. On that
Apply
point,
for vacating order 39 rule 4. If there is a suppression, there is a provision. You can apply under order 39 rule 4. I can give you that leave.
My
After some argument, the learned advocate. Yes.
For the petition in this matter. But I'm challenging an order by virtue of which Milord the learned trial Miss Appellate Court Milord has added Milord a party Milord who is not a party to the suit and has no relevancy or german to the Milord issue in dispute. Now, Milord, if Milord takes up Milord, two orders are under challenge. Kindly takes up order dated 18/6/2026.
All right, come at 2 p.m.
Yes.
18/6.
There are two orders, one after the other has.
So
gone.
this is that order you have said that you have not got
Two
the
orders,
certified
yes.
copy.
Two orders, Milord. The file is in the chamber.
Till now you have not got the certified copy.
So tomorrow is the date fixed, Milord, for hearing of the appeal. Miss appeal.
There was the caveat. You are for the
Yes, yes,
caveator.
yes.
But I suppose my learned friend is
One
not
party,
the
added party.
No, possibly not. Is the other defendants who are the appellants are the
My lord,
respondents?
the dispute is between the two co-owners. These
Both of you are co-owners.
yes.
Yes.
Now there has been a order of injunction against which appeal has been preferred
By
by them.
yes.
Thereafter, another modification application there. There they got an order of restraint order in respect of a liquor license, user of a liquor license by a business by a third party. The property is yet
Oh,
to be
that
purchased.
third party then applied for
No. Another third party.
Another
the-
businessman in an
businessman
adjacent
has
plot
a
comes in and says, add me as a party.
We have nothing to do with it. A proper party. Now, the appeal, the hearing of the appeal should not be stopped in any way. I am not on the way.
question is the issue is whether that person can be added or not. Mr. Rai is an architect of one matter.
No, this is it is their agent. It is their
Mr. Rai is an
they
architect
want
of one matter.
they
No
they
decision
want
was cited.
Of Privy Council, that he cannot.
You will not do research work. You will only ask from Mr. Rai. Scratching of head you will not do.
Yes, my lord, he cannot be added as a party.
Cannot be added as a party. Why?
Not a necessary party. But how can
You have not seen that judgment. He is telling you and you are saying not me. The next paragraph is damaging.
We don't have any objection if this party be deleted.
But that cannot be done without that party being heard. Can it be done?
And that is the thing they want the hearing of this appeal to continue.
And my lord, this third party is also not a party in the suit. He is directly added in appeal now.
Where are the parties?
My lord, this third party. My lord, kindly takes up. My lord, in the same adjacent plot, that is.
No, address. Which place?
That is Narayanpur. Kindly takes to page 50. This is of Not 24 Rajarhat.
Rajarhat.
As described in page 50.
Serve. Otherwise, what can be done, Mr. Chatterjee?
Yes,
How
this
can
should
it
be
be?
done. Both we are agreeing he should be removed. Both we are agreeing.
No. Mr. Chatterjee, both of you may be in collusion. Both of you may be in
at loggerheads. We are at loggerheads.
Loggerheads in either way. But now both of you are saying yes, remove him.
No, by law, my lord, kindly say if this can be permitted by law.
Even if a party has been wrongly added, can he be struck off without hearing him?
No, I need to serve him. My lord, there is no
what I'm saying.
I need to serve him.
Yes,
but there are, my lord, page 50, he describes himself as the proprietor's address as Rajarhat. Kindly see page 50.
In the cost
That is
item,
which
my lord,
opposite
the
party?
That
is which opposite party, Mr.
Opposite party number 6. Opposite party number 6.
6, my lord.
Petitioner is directed to serve a copy. 1 to 5.
1, 2, and 5.
1, 2, and who is 7, 8, 9?
7, 8, 9. They are the
from your
plaintiffs.
group. From
Yes,
your
from
group.
my part.
The learned advocate 2 p.m. another matter. 34 yes. দেখুন দেখি কি আছে।
For adducing secondary evidence.
ইয়ার উকিল বাবু
One of the for the additional secondary evidence, I file a supplementary examination in chief by saying that that document is
for the purpose of
adducing secondary evidence.
Yes,
The photocopy of the original deed agreement. That was
meant for sale.
Yes.
Yes.
That was tendered
That's
to the
registered.
No, this yes, this is registered.
The agreement for sale is the registered one.
Two agreement for sale was there, out of which in respect of one registration was completed and it was acted upon. So for another in respect of the immovable property, movable property, 70 lakhs. That agreement for sale was tendered to the PW1 because original was not there with me at that relevant point of time. It was marked at exhibit B. My lord, I am drawing lots of attention. Kindly turn.
Now what happened? What is the impugned order?
Now, my lord, I came to the subsequently that document, the original was find out that it is lying in the financial company for obtaining loan.
Yes.
I buy a supplementary affidavit. I want that communication from the financial company that original lying with us in lieu of that amount. So I want to produce that same.
Originally want to produce.
Original or my lord, I can ask them to come and produce the same so I can tender the photocopy because the contents cannot be proved. Signature proved. That is why page 70. Can I turn to page 70 once?
Yes. Yes.
There was no movable fixture. My lord, got it? That is 1, 2, 3, 4, 5, 6, 7, 8. 8 line 1. There was no movable fixture and furniture in the suit property.
Yes.
The another agreement dated 25th March is involving the amount of 70 lakhs with regard to the movable fixture and furniture is shown to the witness. This is that agreement. On perusal of the witness answer, in fact, in the said agreement which is executed on such and such involved with 70 lakhs. This document is marked exhibit B.
Yes.
And my lord, the signature which is admitting that your lordship will find.
Now what happened?
Now I came to learn that original is lying. That is why, my lord, can you turn to my application for filing the supplementary evidence in chief along with
the copies of all documents are considered and rejected.
Yes. That your lordship can you turn to page 108. And it turn to relevant portion is 113.
113.
Yes, supplementary evidence in chief. Paragraph 4. I say that Aditya Birla Housing Finance Limited has replied to my mail along with list of documents in the said loan contending that the original agreement for sale dated 25th March 2017 is in custody of the Aditya Birla Housing Company Limited. The email suggests though my email ID number, I have sent the email from my device. Under the control, I have taken the printout from my own device. This is the email dated such and
The
such.
only thing, initially you told that it was lost.
Yes, it was misplaced. Whereas the ground is
If it is lying in the financial company.
That is wrongly, my lord. It has wrongly not been properly instructed. But I am not saying that it has not been placed. It was confronted with the plaintiff. He admitted it is his signature.
That is why it was because it does not match with the statement of the supplementary affidavit. Because initially you told it was lost.
So that is not within my custody.
Right. It's a totally contradictory statement.
That is not within my custody. My lord, I am bowed down to your lordship. My lord, kindly consider the provision. Either lost or cannot be brought. Two options are there. Either lost or cannot be brought. I'm not saying that it was not produced. The one fine morning I bring the same. It was there confronted with the plaintiff. Plaintiff says, yes, it is my signature. But the contents could not be proved. One of the original one.
There is substance in the Yes.
My lord, I got that names, my lord. So, my lord, for plaintiff, two advocates are there, Priyaranjan Vishwas and Devkumar Noskor, and for defendant, learned advocate Chittonath Sarkar.
This application under Article 227 of the Constitution of India
35, my lord, I'm appearing for the petitioner in this matter. My lord, what happened, my lord, your lordship, my lord, kindly takes up the revisional application. My lord will find in that revision, my lord, both parties, my lord, before this honorable High Court, kindly takes up, my lord, page 26.
Yes, what is the impugned order?
My lord, the problem here is, my lord, the learned trial court, my lord, since, my lord, a 13B is being filed there, pursuant to, my lord, an agreement reached before this honorable High Court, where High Court directed both the parties recording the settlement, that in view of this settlement, 13B be filed. My lord, we filed 13B joint. Now, my lord, after that filing of 13B, my lord, we have taken withdraw, both the parties have withdrawn, my lord, the proceedings, my lord, which were pending against each other. Now, my lord, what is happening is, my lord, the opposite party husband, my lord, is not appearing in the proceeding in the court below. Now, my lord, after filing, he is remaining absent. Now, my lord, the court, my lord, is of the view that how long I will keep 13B pending. Now, my lord, situation is, my lord, we are staying apart. My lord, we have reached a settlement here, which is a part of record of this honorable High Court, which says we will be separating ways. 13B filed pursuant to that. Now, if he chooses not to appear there, my lord, my status remains then marital. Then my status, my lord, which is 13B, my lord, is goes for a toss. My lord, is takes a back seat. Now, my lord, in this situation, I choose, my lord, to approach before this honorable court by challenging an order, my lord, where the learned trial court is giving me last chance. Even
What can be done, Mr. Chatterjee? How
no, my lord,
long it will be
I
kept
want,
pending?
my lord, I only want, my lord, the insurance of the presence. My lord, if he is
How
put
can it
on
be
notice
done?
by police. Otherwise, he has to take a stance. My lord, he cannot. My lord, kindly visualize the situation. My lord, kindly takes up page 26, the settlement reached here.
Please show me the provision that can be done.
My lord, it's not about
Because
provision.
law says, Mr. Chatterjee, the law says both parties have to move. If one of the parties chooses
Suppose,
not
my
to
lord,
move, it will fail. Then your remedy lies elsewhere.
Now, suppose, my lord, a party who
Mr.
gives.
Chatterjee, if both the parties, the law says, both the parties have to appear at the time of filing and at the time when it is heard or at the time of moving. So these two stages, both parties have to appear. Now, it's a divorce by mutual consent. If at the final hearing, one of the parties do not appear, it should be presumed that he has withdrawn the consent.
No, my lord,
Cannot be a divorce
my
by
lord, here I
mutual
join
consent, Mr.
my lord,
Chatterjee.
there is some factual difference here. My lord,
Maybe.
here I join an issue. My lord, kindly takes up, my lord, at page 26.
Strategy, if you want to rely upon the settlement reached before this court, if you want to maintain that is a divorce, that is a divorce.
No, my lord, he gives, my lord, his
It's a
recording of
division bench
settlement
judgment
before this honorable court.
which says that the mutual consent divorce can only be granted by the district judge.
Absolutely. My lord, I am
So-
not on that. My lord, I am on, my lord.
Agreement for violation of that, you take steps.
My lord, exactly, my lord, where do I take steps? My lord, the agreement has reached before this honorable court.
Yes,
He gives an
where it was taken.
My lord, kindly takes up page 26. This was filed before this honorable court. So, my lord, now, my lord, if he is moving away, my lord, I take this agreement to be an undertaking before this court.
No. This was filed. What was the order passed on this?
My lord, thereafter, my lord, kindly takes up the order.
Passed on this civil
Yes,
division
yes.
application. What
Yes,
was
yes.
passed?
Page number 48, na? Kindly takes up page 48.
No, it was before the mediation.
Yes, my lord, this was brought before this court. After recording that settlement, this honorable court, my lord, in that civil revisional application, passed an order.
No, this settlement was before the mediator.
It was recorded by the mediator. Mediator
Yes.
record settlement. My lord,
Yes.
now, my lord, this settlement, my lord, forms part of the order also. My lord, kindly takes up, my lord. Page 48. Order dated 17th of February 2025. The fourth paragraph or the last paragraph of the first page of the order. Now, my lord, we approach this court by saying, my lord, apropos the agreement, my lord, we have filed 13B.
Here that cooling off period was directed to be preponed.
Yes.
That was the only order.
Yes.
Now, Mr. Chatterjee, you have only agreed that you will file an application for mutual consent. That's the only agreement. Then the parties have filed. Now, it's if one of them withdraws from that consent, that's permissible under the statute.
No, my lord.
Because for that, Mr. Chatterjee, consent has to be till the final date. That's the object for directing both the parties to file jointly and to move the motion jointly. That's the requirement.
Yes.
So if they file jointly, subsequently one of them does not appear, it shall be deemed that he has withdrawn the consent.
My lord, at page 49.
Chatterjee, we are wasting time.
I know, because this is something, my lord.
Will
This is something, my lord, more of a point of law than, my lord, the situation which has occurred. My lord, can you turn to page 49? My lord, I withdraw my all proceedings against my husband. My lord, husband also.
Mr. Chatterjee, for that you have to take steps. You have to advise
Then-
your client accordingly.
Then, my lord, recording
That
this.
cannot be a ground for allowing your application.
No, my lord, today, my lord, I beseech, because this settlement has arrived pursuant to the direction of this court sending it to mediation. After mediation records the settlement, this Honorable High Court passes an order.
Only thing is that he is now not consenting.
No,
That's
it's not.
the only
He has
presumption which can be
consented
drawn.
because he has partly availed that agreement.
Mr. Chatterjee,
Now approaching the court.
at that point of time, he might be having the consent, but now he is not having the consent.
My lord, it is reluctance, not consent. Now, my lord, this 49.
Either way, if reluctance is also deemed to be no consent.
My lord, page 49.
Mr. Chatterjee, I think.
My lord, I would only say, I will only say, my lord, if he doesn't choose to appear, my lord, in the court, the trial court may be powerless, saying that in 13 May I cannot force somebody. But today, Honorable High Court can, my lord, call this person, my lord, on dock.
By
No, to say whether he is agreeing or not. If he agrees, then he has to appear.
no one can be forced to give consent, Mr.
No,
Chatterjee.
he records his consent by this order.
In a way, you are trying to force someone to give his consent.
This
That
is
cannot
done.
be done.
My lord, this is done. Now, my lord, if he is avoiding court, my lord, it is not that he is not having consent.
Law permits him to avoid the court. He is doing that.
My lord,
it's not Mr. Chatterjee. It's not. If the law permits, because the procedure is that.
My lord, is an settlement which is reached before a mediator is not executable.
You execute that.
My lord,
Nobody is
if
stopping
that
you
is
from that.
executable, my lord, simpliciter that order, my lord, where, my lord, by the virtue of settlement, if 13B is filed and that being executable.
Mr. Chatterjee, the agreement is both of them will file a joint petition. That has been done. That's the agreement.
Then, my lord.
That's the agreement, not after that. So someone is withdrawing that.
Agreement
does not say no one can withdraw that consent.
Lord, nobody is
Chatterjee, I think,
withdrawing. Lord, nobody is
advise your client accordingly.
Then, my lord, may I say, my lord, where do I file this
Mr.
execute?
Chatterjee, yeah.
Where do I file this execution of, my lord, agreement reached before the mediator?
It's up to you to
That is
advise.
exactly 227, my lord, which comes into picture. My lord, I am in this article 227 jurisdiction where I draws my lord's attention. My lord, this agreement we execute.
Now you are on the orders passed by the in a matrimonial suit. You are challenged. So it's that if you come up with an appropriate application for execution, I will consider that. Then I will apply my mind in that way. Not now.
My lord, kindly, my lord, supervise. My lord has number of times has fallen, my lord, supervisor's jurisdiction. Everything can be taken consideration and care of. My lord, if
Not in
something
this,
illegality is
Mr.
happening.
Mr. Chatterjee, because you will not be remediless. It's the please consider at one point of time if the consent is withdrawn.
I could have understood. He goes to the court and said, I have no more consent.
Mere
But he's not coming to court.
Mr. Chatterjee, mere non-appearance means he does not have consent. As simple as that.
Then, my lord,
if you want, I can record that. If that will serve your purpose, I
No,
can
that will
record.
demolish my purpose.
Yes.
My lord, page 40.
That is what I am saying.
My lord, only thing, page 49, the first paragraph of that.
Page 49.
49. In the order itself, the learned council will jointly submit that the parties are living 7th of January and there is no chance of salvage to the marriage of parties. And in view of this, my lord, everything has happened.
Still now, irreparable breakdown of marriage is not a ground of divorce.
It's not. Now, my lord, it's not a ground, but same time, my lord, in umpty number of cases, my lord, it is not unknown, my lord, Supreme
I
Court
can
is saying
s-
that High Court to
I can
consider
say
this.
to the same mediator.
Well, then, my lord, subject to correction, my lord, then I will have a liberty to execute this agreement which is
That
reached.
is already there. I will not.
My lord, then, my lord, the procedure for executing an agreement which is reached in mediation, my lord, I respectfully submit as per, my lord, my knowledge goes,
If
this
you are
is the
liberty
forum.
to take steps, I cannot.
My lord, before whom?
That you have to advise. I have lost that capacity, Mr. Chatterjee. That capacity I have lost now.
No, my lord, subject to
Advisory
correction.
capacity I have lost
Subject
now.
to correction, my lord, mediator cannot.
চলে আসুন।
mediation takes a stance, parties act on that. My lord, then if finally,
What is
my
the
lord,
reason, Mr. Chatterjee?
then my lord, the sending of mediation should be stopped.
No, what is the reason for this failure of 13B? Might
Right.
be you are also responsible.
No. I am approaching, my lord. He is not coming to meet his own child. Now, if he remains absconding, my lord, it's not my fault.
Yes. Yes, call the next matter.
I'm for the plaintiff petitioner, my lord, plaintiff appellant petitioner. Last occasion, my lord directed me to.
Yes, why it was fixed for clarification?
Yes, my lord. Initially, respondent.
Now it has been clarified.
Clarified application
Please
was
give,
made, my
please
lord.
give me the order sheets.
This is the entire order sheet of title appeal number 3 of 2018. I'm placing two orders, my lord. One is order number 26 dated 7th of February 2024. Where clarification.
6th of August again for clarification.
Clarification, my lord. Kindly see what is the clarification. 7th of February 2024, order number 26. Today is fixed for hearing. I'm reading the
2nd of
7th February 2024.
Yes.
The report received as per report of the newspaper publication report is not tally with the memorandum of appeal fixed 12 July 2024 for clarification. Thereafter, my lord, all the respondent appeared and they are contesting.
All the respondents appeared.
Yes, my lord.
So why are you not clarifying this?
Clarifying, my lord. Next
Again for clarify.
Step was taken on order number 32 dated 11th of March 2026.
Respondent number 2 has appeared.
Yes, my lord. 2 appeared.
So you get it clarified again on 6th of August. It is fixed for clarification.
Order number 32 dated 11th of March 2026. Steps taken for clarification.
Photocopy of the
Original
subsequent orders. Yes. Yes.
On the earlier opportunity, the lordship was pleased. About whether High Court can interfere under Article 227 where there is statutory
Statutory prohibition, I have forgotten. Yes, what is this?
This is under
What is the-
Consumer Protection Act, recall. Consumer Protection Act, recall, I had cited a judgment. But now what has come up, my lord, this is not under 19 Act, this is under 86 Act. Now the judgment is more applicable, my lord.
Lordship, I have prepared a synopsis of the argument.
Synopsis, what is the synopsis? How many judgments you have annexed? On what point?
On
On what point? On what point, please? Maintainability of 227 when there is an express bar in the statute. Please give me one judgment. You need not cite 9 judgments. What according to you is the best one? Please cite that judgment.
According to the all are applicable.
Best. All are applicable, but which one of those is the best according to you? Please cite that. Il Chandra Kumar is on a different proposition altogether. Madam, Il Chandra Kumar is on the Administrative Tribunals Act. It took away the jurisdiction of the High Court under 226, 227. I think perhaps section 25 or 26 of the Administrative Tribunals Act. That virus was challenged on that ground.
It has expressly said that Article 6 to 27 cannot be
Forms a part of the basic structure. I agree to that. But please cite the judgments on this point. That is neither here nor there. This is very broad. The ratio is a different thing altogether.
matter MAT 1948 of 20.
Mr. Laidi, are you serious with this?
But this will create ramifications, my lord.
What ramification?
Well, what ramification? If my lord allows this, this will be put as precedents, and all orders which are now taken away, my lord, will come up. But I am on ramification. I am not on the merit of the matter, my lord.
I am not on the merit of the matter, Lordship.
Or it will create ramification, my lord. When under the 86 Act,
Not you, Lordship. Only a procedural order which can be.
Supreme Court says there is no power of review or recall.
So what is the main issue?
What happened, my lord? They had filed their evidence. We had filed the questionnaire. Then they had to file their reply to the questionnaire. 2 dates they missed.
Not
Let me say.
Madam,
Please.
you will be getting your
I am an
chance,
officer
yes.
of the court, please. On the fateful day, what happened? The advocate was running from 2 courts to 3 courts. Whatever in the petition is that he had instructed a junior to take passover or something. He could not take passover. The court closed the charge. Now, after closing the charge, they filed a review application. The tribunal said, the commission said, we have no power to review and dismiss the review petition. Therefore, they have come up before this honorable court. Now, the commission has no power to review, but the Supreme Court has said, and
I have got those judgments. I have told you on the last occasion that if there's no power to condone the delay by the appellate authority in 226, it can be done. Please give me one judgment.
Because I have for people have list of judgments. I mean, it's a judgment to
diamond difference করা দেখার নাই একদম পেপারটা দেখো ডায়মন্ড পেপার
No, we have not brought. Where is that judgment that if the appellate authority do not have the power to condone, High Court in 226, 227 can condone? Where is that judgment? You have not brought that judgment. I told you to bring those judgments.
Lordship, I have come across all these. Lordship, all are saying that
Suncraft Diamond Beverages is on a different point on the Customs Act.
Lordship, there is a statutory appellate authority of the income tax. Despite that, your lordships are still entertained. Lordship, a very short. Only my claim is
He's raising a point of jurisdiction. There's a statutory bar. And you have not brought those judgments. I asked you to bring those judgments. Where there's a statutory bar, there is no power to condone. The court 226, 227 has condoned. And you have brought those line of decisions, El Chandra and other things. Because here the issue is, if there's a statutory bar, so there is no wrong in the order passed by the authority. Please consider this.
Lordship, erroneous understanding of the order.
There is no erroneous understanding.
It's erroneous because Lordship is neither review nor recall in the sense
Then what it is?
it's a procedural order.
Under what provision it will be done?
Procedural order can be changed on.
Under what? Please show me the power under the statute. Please show me the power under the statute. Please show me that the statutory authorities, they can do this. Because there is a specific bar. No review, no recall. Please appreciate this.
Kindly come to
Which judgment?
Assistant Commissioner of State Tax versus Commercial Steel Limited.
2021 SCC Online SC.
2021 SSC online.
SC 884. Which page? You have not given the pagination. Madam, please give the serial page number. I am making it not today. And please put the page numbers against those judgments. Not today. Yes. Yes, call the next matter.
It is retain its position. It retain its position.
Yes, yes. Yes, next.
Number 38.
Yes. What is this?
In a probate case, I am the objector. And this is in a probate proceedings. My mother, they say, my mother executed 2 deeds.
Mother is the executrix.
Testatrix.
Sorry, testatrix. Yes.
Before that, mother executed 2 deeds.
Yes.
I am the elder sister. In my favor, gave some property, and 17 katas gave to the only son.
Only son.
Son.
So she had 2 issues.
2 issues. One son
and 1 daughter. You are the daughter.
I'm the daughter, married daughter. Now, what
so
happened?
These 2 property,
and the remaining property, even my mother acquired during after sale, even after deed of gift to me and my brother. Also
she acquired some properties.
And also some remaining property that was left.
She executed a will.
My brother did not inform me, even did not allow to attend my mother, ailing mother, admitted in cross-examination. Rather, say that an will has been executed. My mother executed.
What is the impugned order?
Impugned order, I wanted, my lord, to get an appointment of handwriting expert to compare the signature, which primarily, my lord, if your lordship look into the...
Compare the signature of your mother?
My admitted signature in the registered deed and the present. My lord, if your lordship...
Rejected.
Rejected says it is for the rarest of rare case, it should be done. My lord, if your lordship kindly, my lord, take trouble.
The deeds have been admitted in evidence. Those deeds.
No, yes, marked exhibits. Now, my lord, if your lordship, I have just got the, my lord, if your lordship kindly turn to page 57A, 57B, page number. Well, the important point.
Where have you challenged that execution? Please show me.
Yes.
Execution signature is not your is
Yes.
not your mother's signature.
Yes,
Please
yes,
show me in the
yes,
written
yes.
statement.
Yes, yes. My lord, the written objection, one thing, my lord, kindly mark it that the mother executed the will allegedly on 2011. Within 5 months, mother died in 2012. She filed this probate case 2019. Even no citation was made. Before that, I filed a partition suit that was pending. He did not appear, and ultimately,
That is the difference. Please show me that.
Ultimately, yes, my lord, my lord, just my lord. If your lordship turn to the page, my lord, I believe page 32.
32.
32. Written statement of the opposite party. My lord has got it.
Yes, yes. Which paragraph?
At the alleged will of late Usarani.
So please show me that paragraph. Where
In the first line, it has been manufactured with ulterior motive and such probate in respect of such will cannot be granted. This first line. Next, the opposite party, being the elder sister of the petitioner, was compelled to file suit for partition and injunction against the petitioner in the year 2013, being titled suit number such and such. Next page, that it was stated that Usarani Bhojmuri, paragraph 4, executed the alleged will on 28 September 2011 and she died on 9th day of March 2012. But the probate case was filed long after the death of the testator on 24th September 2019, and no summon in respect of such case was sent to the opposite party. Next, paragraph 6, the alleged will is false, vague, fictitious, and
That is your application under section 45.
Minor.
Section 45 or order 26?
Yes,
rule
yes,
10?
order 45, section 45.
Yes. Where is that application?
My lord. Probably page 50. My lord, 42.
At what stage you have filed this application?
Yes, my lord, when, my lord, the evidence was when my documents were marked exhibited, and he is even in cross-examination accepted that yes.
No, what is the stage now?
My lord, stage, my lord, after this, my lord, page 51, kindly.
Argument.
No, page 51. Section 45. Petitioner file an application craving for probate. My lord,
Mr. Mukherjee Lanet
affidavit service kept with record.
Where are those judgments at a belated stage also that can be filed? This application can be filed. You have not brought those.
No. Yes. Should I give my lord?
You have brought.
Yes, Supreme Court judgment.
Supreme Court judgment you have brought.
Yes.
What is the cost title?
What is that?
What is the cost title?
That is what I don't know. I am not so prompt people like your lordship. That is my lord, 1979 Supreme Court, that even the court, being the expert of expert, even have to.
No, not on that. Even after the closure of evidence, this can be
Yes,
done.
that is my lord, not disputed. They are also
On this will, probate.
Yes. Your lordship right.
You have got the judgment.
I have before the experience court, so I did not think so it will have to be brought.
Yes, call the next matter.
I'm good.
I am appealing with the plaintiff petition.
Petitioner, yes, what happened?
Impugn order, Lordship. A suit was decreed.
Section 5 allowed.
Section 5 allowed.
Against that you have come.
Lordship, kindly solve, Lordship. More than 3 years, Lordship. More than 3 years.
Court was satisfied. 227, it should not be interfered.
No, more than.
Other way around, it could have been rejected. 227, all right, but
if they are rejected, that was the appealable order, Lordship. But more than 3 years and 3 evidence totally contradicted.
Court was satisfied with that. Why shall
Totally
I interfere
contradicted.
with that?
And also court hold that the no medical test was there, even if.
What is the suit for?
Suit for declaration and permanent injunction.
You are the plaintiff.
I am the plaintiff.
You have a very weak case on merits.
I got the decree.
No, now in the appeal. Why are you fighting
Initially,
with section 5?
I a good case.
Otherwise,
Otherwise,
fight it out on merits.
but in this
What
way,
enhancement of cost? 7,000 you are not satisfied.
No.
7,000 you are not satisfied. Remember this when you will be coming up. I will consider that. What should be the cost according to you?
No, sir, I cannot say.
Then I will get an idea that what is the cost which is prevailing.
No, sir, I cannot say so to that extent.
7,000 you have received the cost.
No, not received. Not received.
This will only delay your.
More than 3 years. Only may I.
Length is not material. The sufficiency of the cost. What is the cost shown?
Lordship, specifically, I
has also produced the medical. What is the illness?
Illness, black tools. Lordship, I annex the prescription, page number 32. Lordship,
the longish order.
Lordship,
physicians were considered.
Kindly come the
Section 5 order runs to more than 5 pages. Section 5 order allowing runs to more than 5 pages.
Lordship, kindly come to page 30. Certificate issued by the doctor.
The learned advocate appearing for the petition. Yes.
In the meantime, stay was of
Let it proceed. If it is set aside, that thing will be set aside. Yes, next. Yes.
I have to appear for the petition in this matter. Your Lordship would recall this is the custody dispute. Lordship wanted me to not get back with a
Custody dispute cannot be. Hey, আমাদের blood serving কটা? Opposing.
Then, Lord, I should get the custody immediately.
What is
Lord, Lord, your Lordship recalls, the
What is
facts
this?
of the
What is
case.
this?
I had indicated to your Lordship, Lord, the first order.
Mr. Chatterjee, it will take some time because there's a larger bench. Guys. I think it's a hotly contested matter. First of all, custody matter and looking at the appearance of the learned advocates.
Where Mr. Kormukar is, it always becomes very
And opposed by Mr. Chatterjee.
I never oppose.
Here he is opposing. Lord, then, Lord, I'm entitled to what I'm
Custody, you
asking
want custody or visitation?
Lord, it was visitation. Now I'm asking for custody. The reason is, on the last occasion, I indicated to your Lordship, your Lordship had passed an order by way of which, I went and filed an application for shared parenting. Because
you wanted to take the child for weekends.
Yes.
Chatterjee, what is the problem?
What
Son or daughter?
Two sons.
Two sons.
So Chatterjee, what is
Not
the
possible
problem?
to send them, to the house of the petitioner. If they want somewhere else, I'm agreeable to that. Do not think there are many technical things I can bring up. Even I would say,
Mr.
I
Chatterjee,
don't want to.
Don't be technical in the
don't
issue
want
of custody.
I don't want to.
So after all, he is the father.
He is the father, but he has there are certain things your Lordship knows what happens, in all these matters and how, to get back to the mother, how the fathers use, these sort of, litigation to get back at the mother. He's a father. Very well, he's a father, but he's just the father. He's not a father, who looks after the children. So there, I have no problems with that. But he needs to, get himself more acclimatized with the child. Not at the residence, I'm only on that. Yes, your Lordship is thinking about the lawyer's chamber. Very well.
Lawyer's chamber
Very
may
well.
not be a
I'm on
congenial
that.
atmosphere, Mr. Chatterjee.
I understand, Milord.
Yes.
For the time being, if they want.
What is the present arrangement? In the lawyer's chamber.
Lawyer's chamber. Your
What's
Lordship
the
only wanted, twice a month.
Twice a month.
2 hours, twice a month
I
in
have
lawyer's chamber.
Your Lordship only wanted.
Any day has been fixed.
Not
The child, the sons are studying
That
in
is the main problem.
schools.
Lakshmipat Singhania, they live in Lake Town. Lakshmipat Singhania, is about 10 kilometers away from, the residence. So entire, day goes, in the school. Then in the evening, they have, these days, I'm very opposed to it. But these days, all the children, including
Sundays, Mr. Chatterjee.
not to his residence.
No,
I'm-
why not
let
to
it
my
start.
residence?
I am
May I ask
saying,
this question to myself?
Kormukar,
There are
So,
problems in your residence.
What is the
Sunday,
problem?
Sunday, for some hours, what is the neutral place according to you?
Any day, my house, I have no problem.
Look,
Your
My
house
house.
means
that is the most
that's,
problematic place.
you don't want
My
the
house.
son to go.
Not to the petitioner's house.
Oh, your house.
My house.
Fair suggestion. How can you oppose that?
My house.
The Chatterjee's house.
The Kormukar is I think he knows where my house is, and I assure him that he will get whatever. On a Sunday, probably he will be there.
So, Kormukar, you can also visit at that point of time. I can appoint you as a special officer in case of any dispute.
Lord, that's a very fair suggestion, Milord. Although,
If that is
Lord,
so,
what I was trying to impress upon your Lordship is, Milord,
Mr.
Lord, the
Chatterjee,
way-
your professional activities will not be hampered.
No. I will give them separate place, separate, and this is not even from instruction from my client. These sort of matters, Milord, I don't need instruction.
Lord,
Milord,
what
from my
I am
client.
on is, Milord, the
Mr. Kormukar,
basis on which
please, now although this is an advocate's chamber,
Well, he
also,
will not have that atmosphere.
yes, maybe a different atmosphere. So, if your client is agreeable, please start with that.
Yes.
Please start with that. if it
Lord, this
progresses
start, Lord,
with the passage of time, Mr. Kormokar, if you
May I-
don't
may
have
I?
the company of the child, so it's difficult
Lord, I
for you
understand
to.
what is going through your Lordship's mind. Lord, may I place it this way? Lord, this was the same example, Lord, set last 2 years back. Lord, the visitations continued, and thereafter suddenly
Kormokar,
the
can you
ground
try
is
out-
not
Try
psychological.
out this for 2 or 3 weeks. Can you
Lord, then
try
in that
this?
case, Lord, keeps this matter pending.
Yes, I'm keeping
Keeps
this matter pending.
There is a special officer
Start from-
report. There's a special officer report which says that the children are happy with me, which this psychologist, Lord, is trying to play otherwise.
Psychologist will not forget, sir. I will not.
Kormokar, I'm not on the
Lord,
psychology.
then let an undertaking come from
Where do you
Mr.
stay? Where
Chatterjee's
do you
client
stay?
that the children will
Where
not
do you
be taken.
stay?
So, Lord, I stay in Solve.
And the mother?
Lake Town.
So they can.
Kakurgachi is the easiest.
Lord, I should have a sole access.
You
The
come
mother
and
should
choose
not
the
be there.
room. You come and choose the room.
Lord, the mother should not be there.
Choose the room even.
You
He's
tell
giving
me.
you that option.
You tell me the room which you want.
You also know the rooms. And if you want, I will appoint you as a special officer.
Lord, may I come back tomorrow?
Why tomorrow, Mr.
No, because Lord, he wants.
Tomorrow, you are giving an undertaking, you will be coming.
Tomorrow there is already a resolution.
Lord, Friday.
I do not have any difficulty.
Friday. Friday.
Don't keep it on Friday because.
Lord, Monday to be made is just on this.
There's one more prayer, my lord. Again not with respect to this. But my son needs a passport because they want to travel as well.
Lord, this is the problem.
Father doesn't want to give that. No, I'm not running away.
No, she will run away.
Passport.
She will run away. Lord, the problem is, I tell you, Lordship. Lord, the children coming to my house, sharing time with grandparents is a problem. Lord, going somewhere else is not.
Is a problem.
Tomorrow. Tomorrow I'm keeping it. Let's see what happens. Tomorrow,
Tips.
Yes.
Lunch puppy.
41 next.
41 minutes, before yesterday month, the matter was taken up. And your lordship desire that the other side, my lords, my lord will submit the list of witnesses and how many costs he will be there.
And for the petitioner,
Your lordship, yes, your lordship kindly look.
your lordship directed me to come up with instruction as to how many witnesses will be there on the part of the defendants. Now, there will be 3, my lord, not more than 3. This is my first submission. And secondly, my lord, I would like to apprise your lordship with a fact that this witness needs some extensive cross-examination. My lord.
How many days?
2 days, my lord.
2 days.
2, my lord. 2 dates, my lord. In a gap of 7 days at least.
How many questions you will put to the witness?
My lord, that will depend, my lord, because, my lord, one point I would like to tell your lordship. Tell it.
Is the next date fixed?
17th July. The day after tomorrow.
Your lordship kindly.
My lord, there was passed.
112.
There was passed a local.
Your lordship kindly look into 112.
My lord,
earlier order.
Your lordship will be surprised to know.
Granted sufficient time, 3 days time.
My lord, local inspection was ordered, my lord, by the trial court.
Doctor, only one
112.
thing. Cross-examination is a valuable right. I'm putting them on time.
112.
Yes, yes.
Yeah, cross-examine time and again.
No. Only 2 days was accommodated.
After
2 days, I said.
Page 100, you also can look into.
Page 100 once. The order number 100.
No, there was a local inspection order was passed back in 2017, my lord. That was not.
Yes, and with regard to the cost part,
my lord, the petitioners are too poor, my lord.
Then,
my lord, they even, my lord,
the advocates.
No, that was
2 dates. They have
that was something I was going to submit before lordship. They even can pay me fees properly, my lord.
That's neither here nor there. That's up to you.
Anyway,
between you and your client.
As your lordship will please.
Yes.
Only 2 days, my lord.
Ashun.
That is not the problem.
That is the problem. And you are the land dealer. Construction company.
Earlier cost,
Construction company. 500 rupees.
That has not been also paid.
Earlier cost not been
Not
paid.
No, my lord, no, my lord. There was a petition for recalling the order dated 9/4. That is when I was going to challenge that order, particular order before this honorable court. Why would I pay the
cost of 500?
No, my lord, because
imposed on 5th of June 2026.
no, my lord,
not been paid.
that order has been challenged before your lordship.
My lord, your lordship kindly consider.
The order has been challenged, my lord.
Item number 9. My lord, PW1 started, my lord, on 2nd of August. Item number 9. My
Of the list of dates.
List of dates. Your lordship kindly peruse.
I don't have that list of dates. Copy of the list of
My lord,
dates.
I am handing over the list of dates.
4 times they got the opportunity to cross-examine.
My lord, 2nd of August 2023.
After the
You
interfered
my lord,
a lot.
Item number 9. My lord, more than 1 year, PW1 has been cross-examined.
That was allowed, my lord. That was allowed despite an order.
And
Proceeding has been
Because that was necessary, my lord. That was not unnecessary.
1 year, my lord, has been cross-examined. My PW1, one after another petition. They are filing. The court adjourning the matter. The High Court passes orders. They are flouting the orders of the honorable court.
Not true at all.
My lord, last order you lost, you find page 112.
After the order,
Page 112.
yes, 112.
You lost, you
After,
can look
after this
into-
order was passed, my lord, only 2 dates were accommodated, my lord.
112 will also kindly produce.
Last order.
At their prayer, the court allowed them to cross-examine on the next date and to finish.
Paragraph 4.
Paragraph 4.
And moreover, my lord, this
Prayer of the
witness is a local
petitioner
anti-social.
or
my lord.
recall
What
PW.
happened after this?
Nothing.
Nothing.
What?
13th of February 2026.
Yes.
So that was recalled, and thereafter what happened?
My lord,
My lord, he's not allowing me.
18th of March.
He's not allowing me.
Please allow him to make submissions.
Thereafter, they twice, they got time to 2 days. And they cross-examined, and after completion of cross-examination has been PW2.
By which order the cross-examination was done? Please show me.
Page 100.
Page 100, your lordship will find.
Page 100.
100.
The case is taken up for hearing. PW2, Sudipto Dev is present and he has been cross-examined full and discharged.
Yes, my lord.
Second paragraph.
Second paragraph, your lordship will find.
There are so many local bar resolutions as well.
All recalling.
Once recalling allowed, they cross-examine.
On 18th of March, my lord. Then, my lord, the next date was given on 23rd, just 3 days later. And then, my lord, 9th of April.
PW1.
I am praying before your lordship only 2 days, my lord. 2 days. Well, this witness has been
He's
placed
outside
cleverly, my lord.
He's outside
Local inspection was not conducted even, despite an order was passed back in 2017, my lord. And this witness is a local anti-social, my lord.
My lord, this is, my lord, they are making
I
submission.
would need, my lord, only 2 days, my lord.
Local anti-socials.
Flouting the orders of the court and asking for.
He is not obeying the court's order, High Court's order.
How? How did I?
Three orders has been passed by this honorable court. At their prayer, they have filed written statement after 5 years.
What about our preemption application? That is still pending.
After 5 years, they filed written statement, cross-examination of PW1.
No, only one thing, Mr. Dotto.
Yes, my lord.
By the order dated 5th of May 2026, 5th of June 2026 was fixed for evidence of DW.
Yes.
Now on 5th of June 2026, they have filed an application for recalling of the earlier order of 9th of April also.
Yes.
So that application has been rejected by the order dated 5th of June.
Yes.
But no date has been fixed for evidence of DW. How can it be done? 5th of June, it was fixed for evidence of, prior to that, plaintiff's evidence was closed. Thereafter, 9th of April also. Thereafter, they filed an application for recalling of that order to enable them to further cross-examine. That has been rejected on 5th of June. But no date for evidence of DW has been fixed. After rejecting,
My lord,
an opportunity has to be given.
They moved before the Honorable Court, my lord, on 13th of June. Page 112.
কোর্টের অর্ডার করেছে তো হাইকোর্ট
And by the order of the Honorable Court, he got the chance.
13th of June.
Page 112.
Sorry, 13th of February.
Yes. No. After that, Mr. Dotto, you have produced the order dated 9th of April.
9th of April.
9th of April, please kindly come to the order dated 9th of April.
9th of
So 9th of April, PW2 was closed.
Yes.
He was discharged.
Yes.
And a date was fixed. 5th of May was fixed for DW.
DW.
Now on 5th of May, it was adjourned, local bar association resolution. And he filed an application for recalling of this 9th of April order.
9th of
April order, he has filed an application for recalling. That application for recalling was dismissed on 5th of May. After dismissal, he ought to have been afforded an opportunity to lead his evidence. Please show me that a date was fixed for evidence of DW after 5th of May or 5th of June.
After 5th of June, on the basis of the High Court's order, the court has fixed the hearing argument.
After the order of the Honorable Court, my lord, he got chance to 2 days, my lord, he
to cross-examine. There are two aspects.
Cross-examine.
One is
My lord, I am not opposing, my lord, you also kindly allow them to further cross-examine, and you also kindly fix the date.
Yes.
And
No, here by this 5th of June, it has been fixed for argument.
No.
That's the question. This could not have been fixed for argument without fixing a date for evidence of the defendant's witness.
The defendant's evidence, they are not coming, the court
Ask them to give evidence.
My lord, you also kindly fix the date for DW. For DW,
Is being prayed for, my lord. Only 2 days, my lord.
And my lord, you know what cost they will pay.
This
W1 for a number of days in spite of that order of CO
what is the
308.
ground of recall? What is the ground for recall of PW2?
No, that is necessary. That was necessary.
Please show me from the application what is the ground made.
No question, it is nothing.
My lord, no, paragraph 5 is all I have to state, my lord.
There is no explanation.
Yes, explanation is there, my lord. Paragraph 5.
Your lordship kindly pay. I will not make my
No, no.
submission.
Should I read it for your lordship?
Yes.
Thereafter, the defendant started cross-examination of PW2, who, being not a party to the suit, is a local antisocial, having several criminal as well as civil proceedings registered against him, and the defendant should be given reasonable opportunity to cross-examine that person in the interest of justice. That is the ground, my lord.
This application under Article 2 1 day, 2 days, 35,000, it will escalate.
And make it 50,000, 15,000 then for 2 days, my lord, kindly.
35,000, don't bargain. 2 days, 35,000.
35,000 is something which my clients can
So
pay.
you can pay 10,000.
And 1 day will be,
This
will not,
comes, you can pay
my lord,
10,000.
kindly, my lord, 1 day will not be sufficient, my lord, for this witness to be
Please,
cross-examined. Kindly, my lord, 1 more day. my
Sir,
lord.
I am telling you, cross-examination is an art. Be very brief in cross-examining. That's an art.
I won't do that.
Please don't make a lengthy cross-examination, then you will be demolishing your own case. That much I can tell.
Then, my lord, kindly, if my lord, the cost may be considered, my lord, make it 5,000 kindly.
That 15,000 you are willing to pay. You
For
can
2
pay.
days, my lord. That, yes.
Your lord.
ये रखो तो यार.
Lord, I appear on behalf of the petitioner. Lord, challenge.
यार खुद देखो.
Challenge arises out of, my lord, an order dated 5th June 2026, wherein, my lord, my application under 47, under section 47, read with, my lord, order 21, rule 29 of the Code of Civil Procedure, has to dismissed. My lord, the principal grievance, my lord, what we had.
Where is the opposite party?
Lord, they were here just before Lordship rose. Lord,
Can you ask your advocate on record to
my
call
lord,
this?
my lords.
Yes.
Lord, may I, my lords? My lord, what happened was, my lord, there was a lease which was executed. My lord, my lord, very brief, I'll give your lordship the submission. My lord, there's an award of eviction which has been passed against me. My lord, that has been passed in 2017, arbitration award. My lord, that was stayed in the year 2021, subject to payment of costs. My lord, an execution was already filed before the Learned Commercial Court at Alipur, my lord, which was pending adjudication. My lord, prior to that, my lord, in 2015 itself, my lord, we had, my lord, filed a suit challenging the lease on the basis of which, my lord, my award holder was seeking to execute the award. This is a prior suit. My lord, lordship is aware of Order 21, Rule 29. If, my lord, there's a decree which has been passed by, in favor of one party and against the other party, and there is another pending proceeding before the same learned court and the same parties, my lord, the court may, in its discretion, subject to terms or otherwise, my lord, stay the execution proceedings till such time that the suit is decided. My lord, we were emphasizing before the
suit is filed by you.
My lord, suit is filed challenging a lease deed which has been executed by.
Then you are appearing in this. You are leading him.
Yes, he's very well. My lord, my lord, Mr. Sen is there. My lord, may I?
Yes,
My lord,
yes.
my lord, so, my lord, what happened? My lord, so what happens is, my lord, the
Firstly, before he starts, I had indicated to your lordship what is suppressed in this application, that he is not in possession.
Lord,
today he seeks to resist an award. With this execution
Lord,
of
may I?
an award
Lord, with the
of possession after admitting on affidavit that he is not in possession. And what is also not disclosed, that there are separate awards of almost 70 crores on account of unpaid occupational charges and mean profit.
No, occupational charges is as a ground of, as a condition for stay.
Yes.
Mean profits is a different proceedings also together. So that is
But one of
continuing.
Those execution are different. This is only an execution.
And also, my lord, in
relating
respect
to
of this
delivery
award,
of
when he
possession.
travels to the Supreme Court, to show his bona fide asks them to deposit 25 crores. They do not do that. They withdraw the petition. So these are the facts your lordship will kindly consider.
Mr. Sen, how much time we will be taking? Because I tell you, one matter has been fixed at 4. It's a continuing matter. So I think you will be taking some time. So I'm keeping it tomorrow.
Yes,
how much time will be taking?
Half an hour, my lord.
So I'm keeping it tomorrow.
Yes, it will be probably taken up before I think the execution application is fixed at 12:30. So
tomorrow it's fixed
yes.
at 12:30.
Tomorrow itself is fixed.
Yes.
But then, my lord, it is difficult. My lord, let it.
Execution application, you will be not appearing in that court.
No, but we, well, your lordship will be hearing it simultaneously. The execution will
He is
proceed.
not in possession. He is not in possession. I will show from the documents. Award upheld right up to the Supreme Court. He files a 47. After admitting an affidavit, he is not in possession.
Mr. Sen, because in order to pass an interim order, I have to record some prima facie satisfaction.
Yes.
Because you have just started, I have also not heard you. So if any arrangement can be made by both of you there.
That's what I was thinking, my lord. If
Not in request or respect to him, not in this matter.
Let it continue.
I am
not take me amiss.
I'm
Not in
not
this.
saying that only for tomorrow. Let both parties have asked for adjournment, my lord. I'm not asking.
My instructions are to proceed. There is a direction of the Supreme Court. The matter has to be disposed of in 4 months.
Because
I am out of pocket for the last
kindly
12 years,
appreciate, my
16
lord,
years.
This the trial court is going to execute the decree. Yes, yes. But
Tomorrow, what is the position?
in the morning, I'm some difficulty. But I actually have to, I'm coming a bit late now. There was some personal difficulty. My lord.
At what time do you want?
Around 11, 12.
I think it may not reach before 12.
Very well. And then, my lord, if any passover is sought for, my lord, kindly accommodate. My lord,
Or if it
I will not.
coincides with your coming, your junior can place in the
Yes,
meantime.
yes, yes,
You can take over from there.
And not take me amiss for the.
No. If you are, after all, are instructed by your client, you have to protect your client's interest.
But if we proceed here, then my lord, we will ask for adjournment. Whatever the trial court does, my lord, it is up to them. My lord.
That's up to you.
What
Both
I'm
of
saying,
you
my
can make a prayer. He can oppose.
saying, my
It's
lord.
after all the
But
commercial
is
court.
it possible that the High Court is hearing the 227 and the trial court is proceeding with the execution on that date?
Yeah, particularly, my lord, I will prefer dismissal on the ground of suppression alone.
Suppression in a
Yes,
227.
Gravest of suppression. He is not in possession.
227,
That is
I will only
suppressed.
disclose this order. I will only disclose
Gravest
the
of suppression.
47. This is not a writ petition.
All right, I'm coming. I'm
Lord, if I understand this, anyways, we'll argue it.
We'll come, my lord, back tomorrow.
Any Mr. Sen, any formal recording of
Yes,
one line?
Helps us.
Mr. Sen, senior advocate. Mr. Banerjee, you are in which matter?
47.
47 may not reach because there's a fixed at 4. Mr. Bhattacharya, can you start? Because I have to rise a bit early today because there's. I think Mr. Bhattacharya will continue for the rest of the day.
From 4 to the rest of the day, Mr. Bhattacharya will definitely continue. You can go, my lord.
So tomorrow.
Tomorrow.
43, 44, I was for the petitioner. Well, I come back.
My lord, if I may say something.
43, 44? Yes. Tomorrow.
Come back.
And my lord, item number 50 also, my lord. My premises is sealed, my lord, perishable item.
Tomorrow this will be taken up. Yes. Yes. What will be happening tomorrow?
This was a short matter. It's a resolution, no adverse order. Not adverse. Adverse order. Both sides have. We'll be here together, Milord, on Friday evening. There is give a commitment.
Yes. Yes, Mr. The decisions you want to cite. Yes, please.
Yes, sir.
Not so. I was pressing your lordship, Milord, regarding the tenability of the order. He has a lot of grievance. Milord, the port authorities has a lot of grievance. I also indicated to your lordship, Milord, yesterday that, Milord, it is a dispute inter se a public body vis-a-vis a private person. It is also to be noted, Milord, this is a special act proceeding where a summary proceeding is envisaged. Now, keeping that in mind, Milord, first, Milord, I want to cite, Milord, AIR 62 Supreme Court.
Yes, page.
Milord, 111172.
Yes. Yes.
This is the proposition which has weighed with the authorities. Just কেন 62 বলেছিলাম এটাকে এয়ার ড্রপ করো kindly first, before I show your lordship the judgment, please see the relevant portion in the order. In the order, the order is 1st July 2026. Now please see the portion which that page, internal page, this will be internal page 4.
Yes.
Somewhere 5 lines, 6 lines from the top. It is true that mere filing of an appeal, as my lord very
Yes.
does not operate as stay, but in the incident, the circumstances are otherwise. Stay was granted, and as appears from the record, such was not duly extended. In spite of such a petition being filed, order of status quo being passed by the Honorable High Court with leave to renew such prayer, the appeal being at the penultimate stage of final adjudication. The action of putting a padlock mercilessly tramples upon the notions of rationality, and especially such being put in place a day before the date fixed for hearing. While the question, this was argued, while the question, did the authority have the legal power to do this, might be answered in the affirmative. The question, did the authority exercise that power in a fair or logical way, does not seem to be answered in the affirmative. Hence, this court cannot agree. Keeping this principle in mind, AIR 62, I am placing paragraph 10 at page, internal page 7.
Paragraph 10.
Just give me 2 minutes. Airdrop. চলো করো দেবাংশু জায়গা কি দেবাংশু হ্যাঁ internal page 7. I'm getting a copy for your lordship.
Yes.
Now please see internal page 7.
Yes.
Somewhere in the middle after the subordinate judge Amritsar, there's a question mark.
What is the paragraph? Number 7.
7. It is a part of paragraph 10.
It is a part of
paragraph 10, which continues with begins at 6.
Paragraph 9.
9 begins with assuming.
Yes.
10. What after all is contempt of court? I address your lordship with this. To speak generally, contempt of court may be said to be constituted by any conduct that tends to bring the authority and administration of the law into disrespect or disregard, or to interfere with or prejudice parties, litigant or their witnesses during litigation. We are concerned in the present case with the second part, namely to interfere with or prejudice parties, litigant during the litigation. In the case under consideration, the respondent had instituted a suit in the court of senior subordinate judge Amritsar in respect of his grievance that a certain sum of money was being illegally deducted from his salary. On behalf of the respondent, it was alleged that he had no further departmental remedies to exhaust, inasmuch as the order by which a part of his salary was being deducted was a final order made by the Punjab government after considering the respondent's explanation. On behalf of the appellants, it has been contended that the respondents had still a further remedy by way of an appeal to the governor. That is a matter with which we are not really concerned, as it relates to the question whether the respondent had or had not violated the terms of the circular letter, etc. Milord, please little calm down, Milord, so that time is not wasted. Milord, please see, the appellant Bachan Singh then drew up a charge sheet, and in that charge sheet it was stated that the respondent had gone to court of law before exhausting all his departmental remedies. What would be the effect of these proceedings on the suit which was pending in the court of the senior subordinate judge Amritsar? From the practical point of view, as my lord very kindly got, institution of a proceedings at a time when the suit in the court of the senior subordinate judge Amritsar was pending could only be to put pressure on the respondent to withdraw his suit or face the consequence of disciplinary action. Milord, I read this with my language, Milord. From the practical point of view, the putting of the padlock at a time when the suit is coming up before the Honorable Learned District Judge on the following day could only be to put pressure on the respondent to withdraw his appeal or face the consequence of an action. This, in our view, this, in our opinion, undoubtedly amounted to contempt of court. There are many ways of obstructing the court.
Yes.
Obstructing the court, and any conduct by which the course of justice is perverted either by a party or a stranger is contempt. Thus, the use of threats by letter or otherwise to a party while his suit is pending, or abusing a party in letters to persons likely to be witnesses.
This is interference in the due course of justice.
I am saying this. Why I am saying this? Kindly, Milord, the trajectory of facts here would demonstrate, Milord, that from January 25 till 16 June, there were long periods when there was no subsisting interim protection granted. Milord, no one plunged into an action. What little that we have learned, Milord, from your lordship, Milord, that in the teeth of a pending proceeding, plunging into action, Milord, amounts to some sort of an interference. Some sort of an interference. There are these lines of decisions which, of course, say that mere filing of an appeal does not operate as stay. Again, Milord, when it is brought to the notice of the contempt court, hearing a contempt matter, that an appeal has been carried. Milord, the moment an appeal is filed from any order made by any court, the issue becomes res sub judice and it is no longer res judicata. That is the principle of law. If that is the principle of law, Milord, the issue is now pending adjudication whether the order passed by the estate officer was justiciable or not. The estate officer in his student.
Don't strain your voice so much.
No.
Now we have the microphones in front.
Milord,
Don't strain.
The estate officer rightly wrongly passed an order. The learned court below, in its prudence, was persuaded to pass an interim order from which, Milord, there was no proceeding carried anywhere.
Yes, followed. Yes, what is
this? Is one. Milord, then is
any other paragraph you want to show?
No, this is the paragraph. Milord, I'll hand over copy.
Yes.
Milord, then is, Milord, 1986, 1 SCC.
1986.
1 SCC.
Yes.
And I'm just giving you the lordship the citation.
Page.
Milord, page
193.
Milord, this is the celebrated judgment of Express newspapers, which is also in connection with, Milord, building regulation and etc. Milord, page 133, 86, 1 SCC 133.
Yes. Which paragraph?
Please come to paragraph 117.
Yes.
Milord, Professor D. Smith, in his monumental work in Judicial Review of Administrative Action, Milord, here your lordship is looking at an action of putting a padlock. That is an administrative action here because it is triggered by the end of the port through some note sheet. The concept of bad faith eludes precise definition, but in relation to exercise of statutory powers, it may be said to comprise dishonesty or fraud and malice. A power is exercised fraudulently if its repository intends to achieve an object other than for what he believes the power to have been conferred. Power is exercised maliciously if its repository is motivated by personal animosity towards those who are directly affected by its exercise. He then goes on to observe, if the court concludes that the discretionary power has been used for an unauthorized purpose, it is generally immaterial whether its repository was acting in good or bad faith. But there will undoubtedly remain areas of administration where the subject matter of the power and the evident width of the discretion reposed in the decision maker render its exercise almost wholly beyond the reach of judicial review. In these cases, the court has still asserted jurisdiction to determine whether the authority has endeavored to act in good faith in accordance with the prescribed purposes. In most cases, the reservation for the case of bad faith is hardly more than a formality. But when it can be established that the courts will be prepared to set aside a judgment or order procured or ignored, bad faith is here understood by the learned author to mean intentional usurpation of power motivated by considerations that are incompatible with the discharge of public responsibility. In requiring statutory powers to be exercised reasonably, in good faith and on correct grounds, the courts are still working within the bounds of familiar principle of ultra vires. The court assumes that Parliament cannot have intended to authorize unreasonable action, which is therefore ultra vires and void. Here, yes, there was no interim protection, a padlock. When the timing, the date, and in the light of the fact that something was coming up the following day, such exercise, in my most respectful submission, is not an exercise in good faith. The next judgment. This is, your lordship knows, standing on this side, I did not cite India cables, but I am formally citing it. India cables principle, I am adopting here. The principle of India cables, it has, laid down the law. Justice Anil Sen, as his lordship then was, has succinctly laid down the law, as to, I need not cite, the relevant paragraphs. Your lordship knows better than me.
No, which paragraph you
Yes. Please see paragraph 8. I have carefully considered the rival. The issue here is all the points thus raised by Mr. Kapoor have been strongly contested by Mr. Chakraborty. According to the learned subordinate judge, was right in taking the view that in the facts and circumstances of the plaintiff, company was not entitled to any mandatory injunction on an interlocutory application for restoration of possession when admittedly the plaintiff had been dispossessed long prior to the suit, when such mandatory injunction was the principal relief in the suit. Here is that sort of a question. Here, I just borrow the principle by saying, as his lordship has laid down the law in India cables, that if the situation so demands, by way of a mandatory order, restoration of possession can always be made.
Yes.
Even when there is an admitted dispossession. Now, my learned friend.
Which paragraphs you are relying upon?
In 85.
Yes.
I'm just. Paragraph 8 onwards.
All right.
I'm sorry. If your lordship takes the trouble to come to paragraph 9.
Yes.
So far as the second reason assigned by the learned subordinate judge is concerned, I feel that it is necessary to clarify the legal position with regard to a prayer for injunction as in the present case. As in the present case, the learned subordinate judge appears to have taken the view that since recovery of possession is the principal relief claimed in the suit, the plaintiff cannot claim restoration of possession on an interlocutory application because that would mean in a manner decreeing the suit even before its trial. Reliance has been placed in Rameshwar Lath. But in my opinion, the said decision is no authority for an absolute proposition that no relief on an interlocutory application can be granted under any circumstances which may amount to granting of the main relief prayer in the suit. McNair in the said decision merely pointed out that as a general rule, such a relief is not granted in the absence of an apparent urgency or injury to the applicant. Here, my lord, this is an injury. When I refer to the decision, I find that McNair did take note of and approve of the principle as enunciated in English cases which acknowledge the existence of a power in a court to give such a relief on an interlocutory application as may also be the substantial prayer in the suit. The learned judge took pains to consider whether on the facts of the present particular case any such ground had been made out for grant of such relief, and observe there is no statement for pleading as to the injury which would be suffered by the applicant if he does not set the injunction which he now prays for, and I am not satisfied that there is any urgency in the matter. If the bar to the granting of such relief had been considered to be absolute by the learned judge, it would not have been necessary for him to go into the question of urgency or to the injury suffered by the plaintiff. Granting of such relief was upheld by the Court of Appeal in the case of Haywood versus BDC Properties 1963 to All England Law Reports. Reviewing the earlier authority, it was observed that those cases, I think, do show that it is only in unusual circumstances that a court ought to take the step of granting substantially the whole relief claimed in the action on an interlocutory application. But they equally show that that is a procedure which in a proper case is available. In my judgment, having regard to the admitted fact, the alleged contract registered was not contract at all. This is one of the cases in which it is proper and appropriate to grant by way of an interlocutory application the relief which the judge has granted. The same view has been accepted when the Court of Appeal allowed the appeal and granted interim relief, though it took note of the fact that granting such an injunction meant virtually deciding the action. Mr. Kapoor has rightly drawn our attention to an unreported decision of this court in the case of Lachman Das versus Philip. In this case, the division bench distinguished 40 CWN 1201 by taking the same view as I have taken in the present case. In my opinion, the principle on the point as it emerges on review of the authorities thereon is that if a court is called upon to grant any relief on any interlocutory application, which when granted would mean granting substantially the relief claimed in the suit, the court will be very slow and circumspect in the matter of granting any such prayer. It is indeed true that such a relief should be granted only in exceptional cases, though exercise of such a discretion should be limited to rare and exceptional cases. Still, at the same time, no court should think, as has been the view taken by the learned subordinate judge, that in law there is an absolute bar to the court granting such a relief. In deserving cases, the court should not hesitate to come in aid of a litigant and uphold the cause of justice by granting such a relief. We're not pausing here. This is what exactly the learned judge has done. According to the learned judge, there was complete abuse of power. And therefore, it has upheld, my lord, the sanctity of law. Nothing beyond.
Yes.
And my lord, Nandan Pictures has also been quoted. Now, my lord, to the judgment.
The discussion went up.
Yes.
Now, my lord, two things. My lord, though it arises out of a proceeding under Article 226, my lord, I am tempted to cite, my lord, it is incidentally, my lord, where I deviled in the chambers, my lord, it was one of his favorite, my lord, judgments, my lord, for the proposition, my lord, that in appropriate cases an interim relief can be granted by way of final law. My lord, 2004 SCC 697, my lord, paragraph 11. The courts and tribunals seized of the proceedings within their jurisdiction take a reasonable time in disposing of the same. This is one account of fair procedure requirement, etc. Then the courts are also overburdened, and their hands are full as the conclusion. An order of placitum A at 703, an order of interim relief may or may not be reasoned one, but the factors of prima facie case, irreparable injury, and balance of convenience do work at the back of the mind of the one who passes the order of interim. Ordinarily, the court is inclined to maintain status quo as obtaining on the date of commencement of the proceedings. However, there are few cases which call for the courts leaning not in favor of maintaining the status quo, and still lesser in percentage are cases where an order tantamounting to a mandamus is required to be issued even at an interim stage. There are matters of significance and of moment posing themselves as moment of truth. Such cases do causes dilemma. Milord, then paragraph 12, situations emerge where the granting of an interim relief would tantamount to granting the final relief itself. And there may be converse cases where withholding of an interim relief would tantamount to dismissal of the main petition itself, for by the time the main matter comes up for hearing, there would be nothing left to be allowed as relief to the petitioner, though all the findings may be in his favor. In such cases, the availability of a very strong prima facie case of a standard much higher than just prima facie case, the considerations of balance of convenience, irreparable injury, forcefully tilting the balance of the case totally in favor of the applicant may persuade the court to grant interim leave, though it amounts to grant of final relief. Milord, why I am citing these propositions? Just because the learned judge, what weighed with the learned judge?
Yes.
The fact which weighed with the learned judge is the injustice caused.
Yes.
Injustice caused. And more so when, Milord, the matter was coming up on the following day. It could have waited. It could have said that there is no interim order. Kindly do not extend the interim order. We shall be taking steps. And Milord, the two distinctions, 62 judgment, Milord. And Milord, the two distinctions, Milord.
Yes.
No. Judge would win.
Yes. Yes.
Lord, here it is the judgment of what he has cited is 2008, 8 SCC.
Yes.
348. Milord,
2008 8 টা কোথায় গেল?
If I am not mistaken.
Yes, 2008 8 he has cited.
Yes.
You have given copies.
I have given copy. Is it available or I have to provide them?
কোথায় গেল বলুন তো? দিয়েছে তো 2008 8 টা কোথায় গেল?
Please see paragraph 19.
Oh yes, I've got. এটা আগে রেখেছেন অন্যগুলো। I've got, yes. Paragraph
19.
Yes.
Milord, he has placed, Milord, I am not troubling your lordship because your lordship is to rise.
Yes.
Milord, here, Milord, I rely on paragraph 16, 17.
Yes, 19.
Not straightway 19. We must also take notice of the fact that even a court in exercise of its inherent jurisdiction under 151, in the event of coming to the conclusion that a breach to an order of restraint had taken place, may bring back the parties to the same position as if the order of injunction has not been violated.
Yes.
Milord, so this, in effect, Milord, this judgment, Milord, it cannot be read in isolation.
Yes.
Milord, I do not propose to multiply. There is another judgment which has been cited. Milord, that is also distinguishable on facts.
Yes.
Milord, this is
2006-3.
Yes. 2006-3. Milord, as a general proposition, this is not the law laid down.
Yes.
Milord, I'll just show you, lordship. Milord, paragraph 6.
Yes.
An interim mandatory injunction is not a remedy that is easily granted. It is an order that is passed only in circumstances which are clear. Milord, that is borrowing the principles of Milord Bengal. 85 Calcutta.
Yes.
It is an order that is passed only in circumstances which are clear and the prima facie materials clearly justify a finding that the status quo had been altered by one of the parties to the litigation and the interests of justice demanded that the status quo ante be restored by way of an injunction, by way of a mandatory injunction.
Yes.
And, my lord, paragraph 9.
Yes.
Now, that has been placed before your lordship.
Yes.
My lord, ultimately, my lord, I say.
It depends on facts.
Yes.
Because
It
it's
depends on facts.
on rare occasions, mandatory as a matter of principle.
My lord, I need not address your lordship on
mandatory
this. Your
injunction
lordship
should
may
not
give
be-
me a lecture, my lord, on this. I really don't know. I really want to learn, my lord. This aspect, my lord, I am very. My lord,
Yes.
well, those are the submissions, my lord. Apart from this, my lord, I want to. My lord, insofar as, my lord, our submission, my lord, we do not want to address anything beyond this. My lord, I only want, my lord, that the padlock, my lord, we are really suffering, my lord, something.
Tomorrow 20 minutes, my lord. Just
20 minutes.
distinguish, my lord.
কালকে তো এমনিতে কোট হবে না কালকে হয়ে যাবে
Tomorrow, anytime.
Tomorrow I'm not fixing any time.
No, our submission is over. Kindly.
Kindly fix that time, my lord.
Oh, in Howrah it is also over. বলে দিয়েছি তো আমি আমি বলে দিয়েছি এটা not the notice. They are just going to give a reply on 2 days. In Howrah, the main matter, our final hearing is over.
Mr. Bhattacharya, learned advocate,
Grateful to your lordship. Great.